All right, so we're up to 31 participants. We're just going to get started. Just make sure that when you log in and chat that you're putting your name so I know that you're here. Can everybody hear me?
Yes.
Okay.
Yes.
All right, so we're in Unit 7, page 120, and it's the quiz. So we're going to follow this. Which of the following best refers to the type of lien that affects all real and personal property of a debtor? Is it a voluntary lien, a specific lien, an involuntary lien, or a general lien?
General.
Okay, that's right, general. Okay, priority of liens refers to A, dates that liens are filed for record. The lien with the earliest recording date will always take priority over other liens. B, order in which liens will be paid if property is sold by court to satisfy a debt. C, order in which a debtor assumes responsibility for payment of obligations. Or D, fact that specific liens have greater priority than general liens.
B.
Is it D or no?
It is B.
Oh,
Okay, so we know it can't be the dates that the liens are filed of record, which would
I was
be
trying to see. I thought it
true. Well, it would be true if it wasn't for tax liens. And remember, that would not necessarily be true because tax liens will always take priority over liens, no matter when they're filed. Normally, for regular liens, it would be first in, first out, with the exception of your tax liens. Okay. Okay, the third one is a lien on real estate made to secure payments for specific municipal improvements to a parcel of real estate is an ad valorem tax, a special assessment, a utility lien, or a mechanics lien.
B.
Remember that, right? The special assessment, we talked about that. If it's a
you
utility.
stop taking. You're doing funny things.
What are you doing? Leave me alone.
Mute your phone, mute your computer.
All right, I think everybody's muted now. Okay. Which of the following is classified as a general lien? A judgment, bail bond lien, ad valorem real estate tax, or a mechanics lien?
A, judgment.
A judgment. In dispersing funds from a foreclosure sale, the highest priority is usually be given to a mortgage dated last year, a judgment rendered the day before foreclosure, a mechanics lien for work started before the mortgage was made, or real estate taxes due.
E.
D.
D.
We just talked about that, taxes. Okay, a specific parcel of real estate has a market value of $180,000 and is assessed for tax purposes at 25% of the market value. The tax rate for the county in which the property is located is 30 mils. The tax bill will be $1,350, $900, $450, or $650. And take a minute to take out your calculator in your phone, and you'll see. Use that to see if you can get the answer.
A.
Is it A?
Well, it is A, but I want everybody to calculate it.
I was going to say, can you get us steps how we get to A, please? After everyone try to figure it out.
Yeah, why don't we go back to that? We're going to finish up the 20, and then we'll go back to 6, okay?
Okay.
Because that's going to take us a few minutes to do. All right, which of the following may become a lien on real estate? An encroachment, a restrictive covenant, an easement, or domestic support order?
Domestic support order.
Yes. A mechanic's lien claim arises when a general contractor has performed work on provided material to improve a parcel of real estate on the owner's order, and the work has not been paid for. Such a contractor has a right to A, tear out the work, B, record a notice of the lien, C, have personal property of the owner sold to satisfy the lien, or D, record a notice of the lien and file a court suit within the time required by state law.
D.
D.
Okay. A seller sold a buyer a parcel of real estate. Title has passed, but to date, the buyer has not paid the purchase price in full as originally agreed. To force payments, the seller should seek A, a lis pendens, B, mechanic's lien, C, a judgment, or D, an attachment.
A judgment.
A
It's C.
judgment. It is C. A general contractor will soon file a suit against a homeowner for non-payment. The contractor just learned that the homeowner has listed the property for sale with the real estate broker. In this situation, to protect the contractor's interest, the contractor's attorney will use an assessment, a buyer's lien, lis pendens, and a seller's lien.
C. C.
It is the lis pendens. Taxes levied for the operation of the government are called an improvement tax, an ad valorem tax, special assessments, assessment taxes.
B.
B.
Yeah.
Ad valorem. Which of the following is most likely subject to real estate taxes? An apartment building, a public golf course, a medical research facility, a community church.
A.
Apartment building.
Apartment
It is
building
A
A.
because the others are exempt.
Yep.
And what time frame, if any, is a Pennsylvania contractor permitted to file a mechanic's lien? Is it any time before the transfer of title, up to 1 year after beginning the work, within 6 months of completing the work, or within 6 months of starting the work?
C.
C.
Right, within 6 months of completing the work. A property owner on whose land the city recently installed sidewalks will pay for these sidewalks through, is it a special assessment, an ad valorem tax, monthly billings, a municipal utility lien?
A.
It is the special assessment. When a company furnishes materials for the construction of a house and is subsequently not paid, it may file a mechanic's lien, an estoppel certificate, a lis pendens, or a deficiency judgment.
A.
Right, because it's a contractor. What encumbrances against real property is always monetary? A tax lien, an encroachment, an easement in gross, or an easement appurtenant?
Tax.
Tax lien. What is an example of a voluntary lien? Real estate tax lien, a judgment lien, a special assessment lien, or a mortgage lien?
Mortgage lien.
D.
Right, so when they do the mortgage docs, you're giving them permission to file the mortgage, which is a lien against the property, which means that if a seller goes to sell the property, he cannot sell the property without the mortgage being paid. What type of a lien is a court-ordered judgment entered against the real property owned by the debtor, requiring the debtor to pay the balance on a delinquent charge account? Is it a voluntary lien, a statutory lien, an equitable lien, or a mechanic's lien?
D.
Okay.
Equitable lien.
It's an equitable lien. So we'll look at these, and it's not a statutory lien, and
Right.
it's certainly not a mechanic's lien. And they're probably not voluntarily giving permission for a lien to be placed on their property. So it would be an equitable lien.
Right.
Okay, Pennsylvania law requires counties and municipal governments to adopt budgets and to set tax rates on a January to December calendar, August to September calendar year, July to June fiscal year, or April 16th to April 15th calendar year.
A.
A, January to December.
Right. A lumber company that furnished materials. A lumber company that furnished materials ordered by the property owner was not paid for the materials. What recourse is available to the lumber company in Pennsylvania? Is it A, file a lis pendens as soon as the material is delivered? No recourse. File a mechanic's lien within 6 months after the work is completed, or file a mechanic's lien within 1 year of date of delivery.
C,
It
within
is
6
B.
months.
Yes. Okay, we're going to go back to 6. So this is going to be broken down in order to get the answer. So we know that the property value is,
I'm sorry, Janet.
yes,
That was C, wasn't it?
yes, it was C.
Okay. Okay.
Sorry, I'm still admitting people. Okay. All right, is everybody ready?
Yes.
Okay, so let's read the question. A specific parcel of real estate has a market value of $180,000. It is assessed for tax purposes at 25% of market value. So what you need to figure out is, what is 25% of 180,000? Does everybody know how to calculate that?
Yeah.
Okay, so it's the answer is 45,000. So you're taking 180,000 times 0.25. So you're getting 45,000. Now the mills is going to be 30 mills would be equivalent to 3%. So what you would do is you would take the 45,000 times 0.03, which is 3%, to get the right answer. Does everybody have the right answer?
1350.
Yes.
Okay. Do you understand how we got that?
Yes.
Okay. So we'll move on to Unit 8. And this is going to be about transfer of title. Okay, so what we're going to go over is the basics that to remember. There is a fair amount to go through, but if you're making notes, you probably don't even need to make many notes because I reviewed this, and pretty much everything that you need to know is going to be on the PowerPoint here anyway. So actual title transfer is handled by an attorney or a title company. So when you go to a settlement, you're not running the settlement. Who's going to be running settlement is going to be a title clerk. Now, an attorney could be present, but the title clerk is still going to handle the settlement. The only time an attorney would actually handle the settlement would be if maybe the buyer or the seller, and in particular it would be the buyer, hires an attorney and he's handling the whole transaction and he's doing the title, which attorneys can do title. Then the settlement would take place at the attorney's office. That's not the norm though, okay? Real estate represents owner's extent of their bundle of rights, and we went over this before, the ownership of or right to the land. And when we're talking about the real estate, we're talking about the bundle of rights. This has to do with the transfer of the property as a fee simple deed, basically. Title is evidence of ownership, not actual printed document. So when they're talking about title, I mean, we use title generically. When we use title, we're looking at maybe a title report. Title, when they reference it here, means the actual evidence of some kind of ownership in a property, but not the document itself. So there's three ways that title can be transferred on a property. It could be either voluntary, involuntary, or through a will. So the voluntary action would be you own a property and you yourself want to sell it. You're doing it voluntarily. Maybe you're gifting a property to, let's say, your child. That's a voluntary action. Or you're writing out a will, and what you're saying in the will is upon your demise that you're willing it to whomever you're willing it to, but that's actually a voluntary action. Okay, voluntary alienation. Okay, a deed is the instrument that conveys property title from a grantor to a grantee. A grantor would be the owner of the property. A grantee is who is purchasing the property. A grantor conveys property title to the grantee. This is all done voluntarily. A grantee receives the property title from the grantor. The grantor must have legal capacity to execute a valid deed. And when we say legal capacity, they have to be at least 18 years of age. They have to be of sound mind. So there are certain requirements that need to be met. So we have elements of a deed, and what I'm going to do tonight after everybody leaves, I'm going to send to you a deed. And I think that I'm going to cross out the person's name on the deed and the property address and all that. But I am going to send it to you because I think that I'm going to go over this with you. And these are the legal terms of what's included in a deed. But you're not going to really get it until you see what a deed looks like. Has anybody seen a deed?
Yes.
Yes.
Okay. So, you know, when you see a deed, you're going to see specific things in there, and all of these elements have to be included. Some of these we've already talked about, some of them we haven't. However, when you actually see the deed, you'll go, okay, I get it, because you're going to see how this all plays out. There's no deed attached to this, so right now it's basically a concept, but we'll go over it. So the grantor is the person that is selling it, right? They're granting it. The grantee is the person that is accepting it, and that would be the buyer. When they talk about consideration, consideration is usually, they're talking about money. Okay. So these are the terms over here. So it could be love and affection, but I've never seen it. So consideration would be whatever the house is selling for. Now, you'll see when you're actually practicing real estate and you're going to look to see what a property sold for, you're going to see a property sold for $1. That doesn't mean that that property actually sold for $1 and that's what it's worth. What it means is that the consideration in the transfer of the property was $1, and that would be used in that, let's say I own a house and now I get married and I decide that I want to put my husband on the deed. Or sometimes people are buying a house and one spouse does not have really good credit and they can't be on the deed for some reason or another. But after settlement, the spouse may decide to put them on the deed. That's when you see a transfer. So let's say my name is, I don't know, Susan Allen. You'll see that Susan Allen is the grantor, and now the property is being conveyed to the grantees. Now I'm also conveying it back to myself, Susan Allen, along with John Allen as husband and wife, tenants by the entirety, and it's being transferred for $1. There has to be, in Pennsylvania, I think the minimum is $1. Okay, you have to have some consideration. Does everybody understand that?
Mhm.
Okay, that's basically when you'll see it. Okay, so the granting clause. When you look at the deed, you're going to see in the beginning where it'll say something like, I, John Smith, you know, as grantor, convey and transfer the property to. Now, what I'm doing is I'm conveying the property to somebody. I'm going to be granting it to somebody, right? And then it will just keep, you know, going. Okay, so I'm granting, or, you know, I'm conveying, transferring, whatever terminology they have in there. Okay, and then it would say something like to John Smith, grantee, or John Smith and Mary Smith, husband and wife, in consideration for the sum of money, whatever that will be. And then it will say, for the property located at. Now, normally you do see a property address, but not all the time. Sometimes it'll just say like lot and block and lot number, or parcel number. The majority of them do have addresses in, but not all the time. I just sold a property and address was nowhere to be seen except on the cover of the deed. But the parcel number was accurate. And then we did, you know, when I looked at the deed, I did a look back for the chain of how this property transferred, and it was always the same. Okay. So when you're going through and you're looking at this deed, you're going to see what's called the habendum clause, and that is going to basically convey how the owner, the grantee is taking ownership of the property. Then you're going to see, and we did go over this in class, the legal description.
Can I ask you a question, please? You said that is going to convey how the grant, can you say that again?
How the legal ownership is taken. Remember, we talked about like tenants.
So that would be the grantee, right? The grantee?
How the grantee is taking ownership. Mhm.
Okay.
Okay.
All right.
So I'm going to send to you a deed tonight. I want you all to look at it and to try to at least get the concept of it. And then when we meet up tomorrow, if you have any questions as far as any sections of the deed, just ask me and we'll go over it. Okay? So you're going to get a deed. Just try to dissect the deed and see if it makes sense to you. Okay? And I'll try to pick a deed that is fairly simple. Next, you're going to see the next part of it is going to be a legal description. And when we were doing the meets and bounds, do you remember that legal description that surveyors use when they go out, they survey the property?
I'm having trouble hearing you.
Yeah, I'm trying to mute somebody. Okay. There we go. All right. Do you remember the legal description of the property? Anybody?
Yes.
Okay. So when we were doing the meets and bounds, and there was a whole legal description starting from point of beginning, going 125
Mhm.
feet on, the southeasterly side of, that whole description there would be your legal description. So you're going to see that whole legal description, and that legal description will pass from one owner to the next owner to the next owner, and so forth and so on. Will always be the same for that particular property, unless they subdivide the property or somehow it changes legally. Next, you're going to see if there's any exemptions or reservations on the property. And usually that will be an easement. It may say at some point, right after the legal description, looks like it's part of the legal description, that, there is an easement running along, and it'll tell you exactly where it's running.
Excuse me.
How long it runs for.
Hello.
Yes.
Hey, William, can you mute yourself?
Yeah, I can mute myself, but there's nobody here but me. It's no noise being made.
Oh, I could hear it background.
Yeah, just make sure everybody's muted. Okay. Next, you're going to have the signature of the grantor. Now, when a deed is being conveyed over to the buyer or the grantee, the only one that signs the deed is going to be the grantor, the seller, or grantors. If there's more than one seller, they have to sign off on that deed to convey it to the buyer. So next you would have on there an acknowledgement, which is saying that they're voluntarily conveying the property, and you'll have a notary. And usually the notary is going to be whoever the title person is. They'll notarize it. And so that is also given to the buyer at the time of settlement. However, that's not considered delivery and acceptance. What's delivery and acceptance? What happens after the deed is signed off and you're at a settlement, the title company is going to have that deed filed with the county, whether it's in Philadelphia, Bucks County, doesn't matter. Okay, it will be filed at the county level, so that in the future, if somebody needs a copy of the deed or somebody wants to go and look at the deed, they can certainly do that. It'll be filed of record. And it will also get, a number, a book page and a number assigned to it. Once that's done, that deed or a copy of that deed is going to be sent to the mortgage company and the person that has purchased the house. Okay, they would all be considered elements of the deed. Do you have any questions about any of that? Okay.
No.
I mean, it's pretty simple. Okay, execution of a corporate deed. Okay, so corporations, they can sell properties if they own it, but it's a little bit different. they have to have the authority of the bylaws that will tell them how they can transfer the real estate. It has to go before the board of directors and everybody has to approve it that's on the board. It's going to have a corporate seal affixed to it. Portion of the corporate's real estate is being conveyed, so a resolution authorizing the sale must be secured from the stockholders because they have ownership interest. They also will have to agree to it. And every corporation does have authorized officers that can sign off on all legal documents, and it's usually one person or it could be two people, but there has to be an authorized officer. Could be the treasurer or it could be somebody that has the legal authority to do that. So that's a little bit different. Now, we're going to talk about the types of deeds. And the most common is going to be the general warranty deed. That's the one you're going to see probably about 95% of the time or more.
Janet, are we supposed to hear something?
Yeah, it's not working. I'm trying to shut it down.
Okay.
Janet, can you send us the PowerPoint for 8 and 9? Thank you.
Yeah, what I'm going to do is any of the PowerPoint presentations that has a link to it, if I can, I'm just going to send you the whole presentation, because the presentation really is everything that you have in your PDFs. The only difference is basically some of these have links to them. Every time I go to click the next page, it starts the video. All right, there we go. So we just talked about the general warranty deed. The general warranty deed, it would be highly unusual if you would see any other kind of deed, but we're still going to talk about them. So when you're doing the, or you're looking at the deed, and I usually do ask the title company for a copy of the deed before I go to settlement, just to make sure that it looks okay to me. As a realtor, you don't really need to do that. I just, you know, like to do it just in case. And then when I go to settlement, I do ask for not just the regular documents like your closing disclosure, but I'll ask for a copy of the deed. And I also ask for a copy of a marked up title that shows, normally, if you have a title and there's like liens on it, they'll put an R or they'll scratch it out, showing that that particular lien has been removed. Okay, so when you have a general warranty deed, that's going to have the greatest protection for the buyer. So there's a definition of different words you should know what they mean, or at least what their purpose is. So some of these are simple. They sound like, they're complicated, but they're not. Sessine, that's one of the covenants. It's just a right that the owner has to be able to convey the property. He has to obviously own the property. And this is when a property is being conveyed legally. Now, I had a question, interestingly enough, today, and I really had to think about it. One of my clients is a doctor, okay? I sold him his property, but he was transferred down to Arizona. And now I'm selling his property for him. But the question that he asked me was, okay, when a seller is buying a property, do they have to use a title company? And I said, not necessarily. But what he was saying is that there's a lot of people that are coming in, however they're coming in, from the border into Arizona. And they're doing, like he said, it's like the Wild West down there, how they're conveying all these deeds. And so I said to him, well, okay, this is the answer. If a title company is involved, they're going to want to see a few things. They're going to look to make sure there's no encumbrances. They're going to look to make sure that the person really owns the property. When you go to settlement, they want to see ID. They want to see normally a driver's license or a passport or some kind of picture ID. And what he was saying was, well, they're transferring property, but they're not showing ID or anything like that, because somebody might be selling their property to somebody else who's agreeing to buy it, and they just sign the documents, and then they just go and file them, and they don't even do like title searches or whatever. So I don't know if what they're doing down there, people are getting scammed. I mean, that's possible. I don't know why anybody would want to buy a property without having some kind of a search, for any kind of liens and encumbrances. But apparently this is what's going on down there. And he's heard it from more than one person. And he asked me if it was legal. And the answer is maybe.
Where is this at? I'm sorry, where is this place at? Where is this at?
This is happening down in Arizona. I mean, he in particular is in Tucson. But
Tucson, Arizona?
Yes, he's been seeing a lot of that. And so he said, I've been wondering about this for the last few months, and I kept meaning to ask. I don't know what they're doing down there, and without actually seeing what they're doing. It's not necessarily illegal for somebody to sell a property to somebody else. I mean, the buyer should be smart enough to, well, I would hope they would be using at least a title company. But if they're doing this, and years ago people used to do this, it wasn't, and I see it once in a while, not that it was not legal, but people did get themselves in trouble. And we kind of talked about that the other day when I was saying somebody was coming along and selling a property to somebody else who thought they were getting a good deal. And they would purchase the property, and then after they owned it, they would find out that there was like a lien on the property from the city because the house that was on it before was demolished. So I think that's the kind of stuff that maybe they're doing down there. But the point is, you have to have the legal right to convey it. Now, I do know in Philadelphia, and I'm sure it's happening in other places too, there are people that are scamming. They get copies of the deed and they act like they own the property, and they don't own the property. And they're selling these lots and properties for like a few $1,000s, and they're making money off of it. That doesn't mean just because they have a deed and they say they own it that they actually do, which is another reason why when you go to settlement, the title company wants to see that you are who you say you are, whether you're the buyer or the seller. Now, on a settlement notice, you're going to see they always ask for 2 forms of ID. but I only ever see them ask for a driver's license or a state issued license, or not everybody drives, so they might accept, well, they will accept a passport. So they do want to see that you are who you say you are.
Janet,
Okay, so
Janet,
yes.
what is the big difference? Like years ago, I would see you had a lot of advertising about home for sale by owner. Now, what is the big difference, getting a realtor and selling your own home? I mean, you have to follow all these same steps.
Yeah, you do. Okay, so let's say I decide I'm going to sell my house on my own. And just so you know, people that usually advertise, and this market, it might be a little different, because there are not enough houses around. There's so many buyers. Everybody's trying to buy a house. But for sale by owner, now they decide they're going to sell their house. And a lot of people that do try to do that eventually do wind up hiring realtors because they just feel like they're in over their head. But let's say somebody does decide, right? They can do that. There's nothing wrong with that. But at some point, they're going to either hire at least a title company or an attorney to do their paperwork, right? Most people, like I could decide to sell my house on my own. But if I did that, I would have to disclose I'm a realtor. But let's say I'm not a realtor and I decide to do that. And now I have open house, and I don't mind everybody traipsing through my house, which I actually would. But, if you're trying to sell your house on your own, you're going to have people to come in to look at it. And let's say somebody says, I'm interested in your home. I want to buy it. Well, two things. One is, how do you know that they're even qualified? Now, if you're a little savvy about it, you might say, well, I don't want to show anybody my house unless you're pre-approved, which now they have to show you they're pre-approved. But how do you know how the process is going to go? If you're an average homeowner, you are at some point going to ask a realtor to represent you, not through the whole sale, right? But just to do your paperwork. And you can certainly do that. And realtors, normally, you charge some kind of a flat rate that you will agree to. Or, an attorney, and you call the attorney up and you say, hey, Mr. Smith, I'm selling my house. I already have my buyer. Can you do the paperwork for me? But it still has to be done the same way. If you're using a title company, they're going to want you to have a title search done. If you're using an attorney, they can have a title search done. So in essence, the same process is going to be done, but without the realtor. Or it could be a realtor. Okay? Does that answer your question?
Yeah, it answered my question. But you see a lot of signs now of people have say, I will buy your house, any condition, all that kind of stuff. Do they have to go through these same steps, the title search and all of that? You know what I'm saying?
Okay. So, all right. So we haven't really gotten to this yet, but.
Oh, okay. Well,
no,
I can wait.
I wanted
can wait.
to say this. When you see these houses, we'll buy your house for cash. Okay. Two things. They could be buying the house for cash, but what I see for the majority of them, they're either going to buy it for like dirt cheap, and maybe somebody's desperate and they got to sell it right away because they're in foreclosure, and they would maybe accept a real low offer, or they're doing what's called an assignment. And that is something very different. They're really not buying the house until the day of settlement when they're selling the house. And they're assigning their ownership. Not that they ever really own the house. They'll own it for a few seconds on paper. And then they will, and I'll explain that to you when it's covered in another chapter. But that's usually when you see those signs up there. And yes, it's still a settlement. You still have to go through the same process. Okay. or you should. So another one of the 5 covenants that you're going to see is against the encumbrances, right? And we talked about the encumbrances. So encumbrances could be, anything. It could be a lien, which is a monetary, for a mortgage, which would be monetary, or it could be an encroachment, which would, not be monetary, it would be a physical encumbrance. So you're saying in a general warranty deed that you're selling the house and that you warrant that none of these 5 things, that they're not existing or they are existing, right? It's the highest degree of protection that a buyer would get. So in here, in this situation, quiet enjoyment is against any third parties bringing any kind of court action, establishing superior title. When your buyer goes to settlement, right, they're gonna sign, a paper, and the seller will sign a paper saying that there are no additional encumbrances that have not been, on the title search. And so that's for the protection of the buyer, because let's say the seller agrees to sell the property. And while they're under contract, they decide to take a loan out on the property. And then when the title maybe it's not filed yet. And when the title company is doing their, they're pulling their abstract and they're having the lien searches done, maybe it doesn't come up. Well, we hope it comes up. A seller is not allowed to do that. Could it happen? Yes, it could happen. So that's really to protect the buyer in case an issue like that does come up. The seller is giving them a warranty or a guarantee that there's no additional third party that's going to have any kind of a lien or, any encumbrance on the property. Further assurance is obtaining or delivering of any instrument needed to make good title. So let's say spouses are married and the house is in one spouse's name. Maybe it could be some kind of a documentation that the other spouse doesn't have any ownership interest, or could be a document maybe that the title company is requiring. So there could be different reasons for that, but you don't normally see that. That would be unusual. However, it's part of the guarantee or the warranty or the promise that the seller is passing, a good deed with, and this is the interesting thing, okay, with the intention and the knowledge that there is nothing, it's not clouded, it never will be clouded, and it has never been clouded. The title doesn't have any judgments, liens, encumbrances, okay? And so when it says warranty forever, basically what they're saying is, yeah.
Excuse me for a minute. I think I got lost. Where are you reading from? What page?
In the book, I don't know.
Are you still on general warranty deed?
I'm still at the
page?
bottom of general warranty. Uh-huh.
All right, thank you.
And in the book, it would be on page 128. Okay, if you want to follow me in the book. So a warranty forever.
Hello?
Yes.
So the warranty stuff, it's all for the title company to worry about, not the realtor, right? it's...
No, we're just talking about what are the different types of deeds.
Okay.
You as a realtor, no, I'm going to tell you, I've been doing this a long time. I don't even know if I've ever seen anything other than a general warranty deed, other than when I was working with an investor. And, they have different deeds that they pass along. But the reality of it is the majority, when I said 98% of the deeds are always general warranty. But that really isn't going to be for you to determine. That's going to be up to the title company. Okay? And if there's any question about it, believe me, they will ask you and you can follow up on it. But this is more or less so you understand what the differences are in deeds. Does that answer your question?
Yes, yep. Thank you.
Okay. Okay, I think somebody may not be muted. There we go. Okay, so this is what's really important in here also. Warranty forever. So what you're doing is you're guaranteeing, right, that this is really a good title that's being passed on to your buyer. It not only covers during your ownership, but it goes all the way back to the origin of years ago when the first deed was filed. Okay. Okay, so a special warranty deed, they are a little bit different. These are all similar but different from each other. So in a special warranty deed, normally you would see something like this in either a tax sale or maybe a sheriff's sale, right? The grantor, they received titles, so maybe they took it in a tax sale. So they can grant that they own the property because, you know, they purchased it in a tax sale or maybe through a sheriff's sale when a bank takes their, you know, their property back. And they can also say that the property was not encumbered by the grantor unless there's any encumbrances like an easement or whatever. Right? So the grantor might only have this property for a very short period of time. So also there's a granting clause on these deeds that say grantor remisses, releases, alienates, and conveys. Now, you'll see this also, like trustees or maybe executors, if they're probating estate. They'll say, yes, you know, I've received the title. Yes, I didn't, you know, have any encumbrances on the property, but I can't tell you going back before my ownership or before I took possession of ownership, what happened way back then. They don't know because they didn't inherit this maybe, or they were not given this deed where they had the ability to do a title search and see maybe if there was something else going on with it. Special warranty deeds, tax sales, and yeah, tax sales and sheriff sales. You might see this. Bargain and sale. No, they don't warrant against anything. They just say, hey, I hold the title and, you know, I possess the property, but they're not saying anything like you would see in a general warranty deed. So grants and releases or grants, bargains and sales. I have to say, this is not something that you would normally see. This is an unusual way, and you'll probably never see it. Sometimes you could see it maybe in a foreclosure, but I would think instead of a bargain and sale, you would probably see a special warranty deed.
Janet, what about like a mobile home? Would you see this in a mobile home maybe?
No, usually they would be passing a deed on. I don't think as a bargain and sale. I think you would actually see it as a general warranty deed. That's a good question. I'll go back to when I sold my last mobile home and I'll look, but I think that was a special warranty deed that was used.
Okay. Thank you.
Okay. It does say here buyers should get title insurance, but I'm going to tell you, just make sure your clients always get title insurance, and your office will probably mandate it anyway. I can't imagine them allowing you to represent a client without doing some kind of a title search in case anything ever came up.
Hey, Janet, quick question. What is the difference between the sheriff sale and the tax sale? Is that two different things, or is it all related to the same?
No, there's different types of sheriff sales, okay? You could have, they call them RIOs, real estate owned. They would be your foreclosures. And then there's different types of foreclosures. Your tax sales could be held by the sheriffs, with the sheriff's department or wherever they're holding it. But it's not the same thing as, they're still foreclosing on the property, but it would be a different type of a foreclosure, okay? It's not like if you don't pay your mortgage and the bank comes along and decides to repossess your house. That would be totally different. Okay, it's the same thing with like HUD. HUD foreclosures are very different than if you're doing like a Fannie Mae foreclosure. So each foreclosure, they have all their own nuances. And it's interesting, if you're working with HUD properties, the whole thing is handled so different than if you're working with a bank. All right. And when I think we'll probably cover foreclosures in greater detail. We can go over some of the nuances and the difference with
Janet,
foreclosures.
I'm sorry. Janet,
Yes.
is there certain HUD properties that realtors try to stay away from? Or is it a reason for that?
Yeah, they're not easy to do, and you don't make a lot of money on them.
Okay, I only asked because a few years ago, well, maybe it was in the 90s, I had bought a HUD home. The officer next door, teacher next door program, I'm sure you heard of, for police officers and things like that.
Yeah.
And I tried to buy one of these properties, and I had a very hard time getting a realtor to help me and taking me out to the property. So I actually called HUD and told them I was a police officer, and they actually called Century 21 here and they made them give me my own HUD key because no realtor wanted to help me. So I actually did everything on my own with the settlement. I didn't have a realtor. I literally did everything on my own because nobody would help me because they didn't want to do it because they didn't make any money off of it. I always wondered about that. Was it a reason why? But I figured it was money.
Okay. Well, I can tell you a story about that.
Mm-hmm.
My first or second sale was actually a HUD. Go ahead. Okay, so my first sale or second sale was a HUD sale. And I really didn't know anything about it because I was just starting out. And so I had somebody that wanted to see the property. And I did take them to see it. And of course, then they wanted to buy it. And let me tell you, this was a crash course in HUD sales. First of all, nobody in my office knew anything about them. They never did them. They didn't know how to do them. So I finally found somebody that worked at a different office. And I drove over there and I literally begged this guy to help me because I didn't know what I was doing, right? Because they're done very differently. Normally, when you're doing your agreement of sale, you write an agreement of sale up and you present it. If you're doing a regular foreclosure, you're writing up the agreement of sale and you're presenting it. When you're doing a HUD property, right, you're doing, it's not an agreement of sale, you're bidding. And so
Yes.
HUD has a site that you go to.
Yes.
And yes, and they close. Okay, so when you're looking to put your bid in, these bids are accepted till midnight on Sunday. And if the house
Mhm.
doesn't sell, then it goes to Thursday at midnight, right? Then you
Mhm.
got to check back to see if they accepted your offer or your client's offer. If they accepted the offer, then it's like, hurry up, hurry up, hurry up. Now they
Mhm.
want that agreement of sale and they want everything done, okay? Ideally for them, it would be 24 hours, but they'll give you like 48 hours. And when they tell you they need something, you need to jump. It can't be
Yeah.
like, oh yeah, I'll meet you tomorrow. No, it's kind of like, hi, guess what? You won the bid. What time can you meet me in the morning? Okay.
Yes.
It's very
Okay.
quick.
Yeah,
And
I had a
I
hard
know-
time finding someone to help.
Well, and then the other thing is the poor realtor doesn't really make a lot of money on it either. And
Yeah.
now they're like running around like a lunatic trying to get this all done. And they're not, properly compensated. And that's the reason why realtors don't want to do them. I
Yeah,
got
I
really
had a
good
hard-
at them and I did them
Mhm.
for a while. And then one day I'm like, wait a minute, why am I even doing these? I don't even make that much money.
Yeah.
So now,
I did it on my own. I didn't know the first thing about buying a property. All I know is that the government was giving police officers 50% off. Like the house, say for instance, 58,000. I only had to pay 50% of it. I just know I wanted to buy this house, and at that price, I took $50 the settlement. I did everything on my own. Didn't know what I was doing, and I did everything on my own. Literally, placed my own bid and everything, and they allowed me to do it because no one would help me.
no, and the other thing too is this. I don't think they make it so easy either, right? Because they tell you, yes, you can do inspections. However, you got to hire whoever their contractors are that will come in, de-winterize the house. So, and they only give you a certain time period to get this all done. So de-winterize the house, the buyer pays for that, and then get it re-winterized. Even if you're buying it in 2 weeks, we'll say, they don't really care. It's got to be and re-winterized. And you got to get your inspections all done at the same time that you're getting the appraiser in there. Now, if you have cash, it's not so bad. But when you have a mortgage, let me tell you, and I tell this when I teach first-time home buyer workshops, okay? If your client is buying a foreclosure, this is the problem they're going to have, maybe. Foreclosures are usually not in the best of shape, and I'm sure we can all agree on that one.
True.
So let's say you go in there, or your appraiser goes in there. You've done and you're buying, first of all, you're buying the house in as-is condition, which means it doesn't really matter what's going on with the house. That seller is not doing a darn thing.
Yes.
Okay. The other thing is you get to pay, your buyer will get to pay the entire real estate transfer tax. In a normal sale, it's usually split between the buyer and the seller. In a distress sale, you're going to be paying for that. Now, to offset it a little bit, not all, but some of the lenders, okay, the lenders will say, well, since you're paying for the real estate transfer tax, and if you use our title company, we'll cover the cost of the title, right? They will. It's not a total offset, but it's a help, I guess.
And then sometimes they're insured with the escrow. So you
Well,
get that money for some repairs.
Yes, but the issue is this, okay? Not all banks or lenders want to deal with, foreclosures or HUD properties. So you got to ask when you get pre-approved, do you, will you lend on HUD properties or will you lend on foreclosures? They could say no. But this is where a buyer can get in trouble. Now they have a mortgage, okay? And let's say the appraiser goes in there and says, yeah, we believe that, okay, so the appraisal says, yes, it came in at value, or maybe it comes in above value. However, the following repairs will have to be done. Well, guess what? They're not doing them, but they will not allow anybody else to do them either. Okay? So what do you think happens? You don't buy the house, or your client doesn't buy the house because they don't have the cash, and they're not going to let them to do the repairs, and they're not doing the repairs, so that ends that. Now, I worked with a client who was in one of my workshops. And I tell everybody why I think it's fine if you're working with an investor, but if you're working with a homeowner and you go in and you go, wow, this is questionable. They have an FHA mortgage. I don't think this is going to fly. You need to have a conversation with your client. I usually just tell my first-time home buyers, who are almost all FHA, don't even think about it. I had a client, though. What happened was I sold her a house, and then she decided to buy this other house, and her mother had passed away, and she had cash from her inheritance, okay? So instead of living in a row home, she decides she wants to buy the single home. Now, she had been in my classes before, so, I mean, she knows the drill, right? You know it's a foreclosure. You know they're doing nothing. You know you're not doing anything, you know. Yes. She knows all this, right? And she calls me up before we go to settlement, and she's all excited, and she goes, Janet, she said, do you have a minute? I'm really excited. I want to tell you something. And I said, okay, what's going on? And she said, I just want to let you know that I had a new roof put on the house. Well, I was driving my car. I literally had to pull my car over to the side of the road. And I'm like, oh my God, what did you do? And she, oh yeah. She says, I had a new roof put on the house. And I said, oh my God, why would you do that? And, you know, I said, don't you remember me telling you that you're not allowed to do anything, you know, in the house? And she said to me, right. She says, well, I thought you meant inside of the house. I didn't think you meant outside of the house.
Oh, wow.
Okay? And I'm saying, oh my God, because what would happen if there was, let's say the roofer was up there and somebody fell off the roof, or somebody got hurt, or they dropped something on somebody or whatever? Well, that would be a problem, okay? And it would be a problem for you as a realtor, not to mention the person that owns the property, which in this case, because it's a foreclosure, you know, it would be the bank and everything. I was beside myself. So, you know, I've been teaching these workshops a long time, at least 16 years, right? When I give these workshops now, do you not think I say you are not allowed to do any work inside of the house, and that also means outside of the work? And when I say no work at all, I mean no work at all. And I really make a point of telling that based on my experience with somebody that decided.
And I'm trying to understand why you can't. I missed that part. Why can't you?
She didn't purchase the property yet, though, right?
Yeah,
She didn't
wouldn't
own
like to. She didn't own the property.
So,
Okay, you're talking about, got you. Okay, before, all right, okay.
yes, before she bought the property, she decided to put a roof on because she thought it was a good idea. She could move in the house and it would already be done.
Oh, no.
So, I mean, there are a lot of potential legal issues there, okay?
Yeah.
And
She did get the house, though, right?
she did get the house. And
Oh, thank God.
it is nice. It's a nice house. But, yeah, that was, and you know what? Even when they sign these agreements of sale, it is in the agreement of sale, right? Bank will do no work, and, you know, nor permit any, you know, anybody to do work, you know, to the house. But her interpretation, she thought house meant inside the house. I will tell you, in actuality, if a house doesn't look too bad and it looks like it has peeling paint, maybe on the windowsill, and I go, yeah, this seems like it has a good chance of passing, I would not, because I've done this, okay, I would not let that sale not happen just for that reason. So I might get a little bucket of paint, or a little, you know, little can of paint, and take a paintbrush and just go over the windowsills, right? And anything I think might be an issue. If it's a minor thing, I don't think they're gonna like send somebody out and say, oh my God, did you paint that windowsill? But they won't, you know, they're not gonna let, and I might even talk to the other realtor about it and say, listen, house is in really pretty good shape, but you know, I'm a little concerned about that windowsill. And do you think it's okay if I go in there and just throw some paint on it so it doesn't become an issue? And normally they would say, yes, just go in and do what you think you need to do. It's only a minor thing. But you cannot tell your client that, yeah, why don't you go and get a crew and send them in there and let's whip this place into shape. That would be a big problem.
Not until after they buy it.
After they buy it, they can do whatever they want. They own the house. Okay? But before that, no. Now, with that being said, I mean, not for foreclosure, but sometimes if somebody's buying a property in as is condition and the buyer is okay with it, if an appraiser goes out and they go, the report says repairs are required, the seller wants to sell his house. And I would say it's usually not a problem for the buyer to go in there and do some things or send a contractor in there to do some things. And I got to tell you, representing buyers or sellers, I've had sales where that happens. But that's in a regular sale. You're not dealing, with the foreclosure. You're dealing with people that you can communicate with and, that have the same goal in mind. When you're dealing with the foreclosure, this is their attitude. Next. Because if it doesn't work out, they don't really care. They just move on to the next person.
Mm-hmm.
Very different.
When we bought our house, we bought a foreclosure back in 2013, but we had to pay all cash for it.
Yeah. Mortgages can be hard to get, and lenders really frown upon it.
Yeah, we had to go like over 30,000 over asking too.
Oh,
And it was like a dump. It was like a dump. Like the only thing that's left from the original house is like the foundation. That's it.
All right. You know what my opinion is? If you're a contractor, I get it. But if you're going to be like a regular homeowner, by the time you buy that property and you really fix that house up, are you not better off buying a house that doesn't need a lot of work and that needs more like cosmetic things?
No, normal people would be, but we are like construction. So we did it ourselves. So now our house that we have so much equity in.
All right. Then your situation would be different. Okay. You're doing the work.
Yeah.
But if you're a regular buyer, right, and you're not doing the work, and let me tell you, most people are not that handy. Once in a while, I like estates for that reason, an estate sale. But if you're not handy, I've seen clients who they go in and they think they're handy and they're going to do all this and they start ripping their house apart. And then 5 years later, they're calling me and asking me if I can sell the house for them. And I walk through and I'll say, what happened? Oh, yeah, we tried to do that, but we never really finished it, or we didn't get to it, or it was a lot harder than we think. So, the fact that you could do that was great, but not everybody has those capabilities.
Yeah.
Interesting, though. Okay, so the quitclaim deed, the least protection of any deeds. There's no covenants, there's no warranties, conveys whatever interest the grantor has. Normally, I see this in two things. If there's a issue with the title, somebody's name is spelt wrong, there's a typo, or, when the description was typed, maybe the person that was typing it was dyslexic and they left a few words out, I don't know. Or if you see it's inherited or conveyed to like husband to a wife, or whatever, you might see a quitclaim deed then. You don't really need any warranties. The warranties are already existing in that initial deed. So a quitclaim deed just kind of like gets the job done, basically.
So Jan is almost like a notary.
Well, no, I mean, a notary is a person that is going to notarize the deed, but the deed is the actual deed, it's the paperwork that conveys the
Okay.
property. So you know what, let's just say I've decided to put my husband on the deed, right? There would be nothing wrong with me doing a quitclaim deed. I mean, he knows that, you know, there are no encumbrances because, you know, we've lived together and, you know, for umpteen years, and, you know, in that situation, it doesn't really matter. You know, there's no warranties expressed, but, you know, in a situation like that, there doesn't really need to be, right? But that would be unusual. And I have to tell you, even if I was to add my husband on the deed, we'll say, I probably would still do a general warranty deed. I don't see any reason. Maybe it might be a little bit less work doing a quick claim or something, but probably I would do the general warranty. Okay. All right, so deeds and trust. All right, the trustor, who is the person that is giving, right, the owner is giving to the trustee, who is in charge of the trust, right, the trustee, for the benefit of the beneficiary, okay? This is when you would see this. And honestly, I think I've only done one of these, and that was a few years ago. And it didn't really matter to me because I'm not the one that did the deed. This whole deed process was actually done by an attorney for the bank. They did, you know, the transfer and basically all the work. But that would be the reason why, okay? So it's executed by the trustee. It was court approved by a court order. They petitioned the court for the purchase. The court granted it, and they signed an order saying that it was permissible. The execution of the deed was done by the trustee on behalf of her, you know, the beneficiary, who the trust was set up for. Okay, deeds executed pursuant to court order. Deeds are established by state or statute and are used to convey title to property that is transferred by court order or by will. That could be a foreclosure, or it could be by a will. The form of such a deed must conform to the laws of the state in which the property is located. One common characteristic of such instrument is that the full consideration must be exactly stated in the deed. And that would be, when they're talking about consideration, they're talking about the sales price. What did it convey for? Examples would be an executor or an administrator's deed. And an executor or an administrator, they're the ones that are overseeing an estate. A master's deed or a sheriff's deed. Okay, you can go over this because we actually just went through this. Deed name, just go through. This is a good study guide for you. General warranty, special warranty, bargain and sale, quick claim, deed and trust, trustee's deed, or pursuant to the court. Go through them and just make sure that you understand, you know, the differences. Normally, if you would see a question, you would probably say what gives the greatest protection or what gives the least protection. They would be probably questions like that. Transfer tax. Okay, you're going to see this on when you go to settlement with your client. You're going to have what's called a closing disclosure. And so the closing disclosure is basically a statement that will show the amount of the sales price of the house. It'll show all different kinds of expenses, which will be, the closing cost. Part of the closing cost is going to be your transfer tax, okay? So it can be 1% or more payable when deed is recorded. So you're going to see this on the closing disclosure, and usually it's split equally between the buyer and the seller, usually, unless you're doing like a foreclosure or unless there's another agreement for like a distressed property that's made ahead of time. But for normal sales, it's going to be split equally. May be imposed at a state, county, or a city level. So the state is going to have a percentage, and then the municipality might even have a percentage that they're going to be charged in the real estate transfer tax. It's going to be based on the sales price of the house. We're going to talk about the deeds that are going to be exempt from this. But in Philadelphia, when they're doing a transfer tax, okay, let me talk about the counties surrounding Philadelphia. They're usually 2%. And so 1% is paid by the buyer, 1% is paid by the seller. In Philadelphia, it is different. Buyer pays 2.14%, and the seller is going to be paying 2.14%, right? Because the tax basis for Philadelphia municipality is higher than what the counties are charging. Now, there are exceptions. Parent and child or siblings. So if you have like a spouse or you're adding somebody to your property, okay, you're not going to have to pay taxes on that, right? So just go over that and know who is exempt.
How much are the taxes in Philadelphia again?
For each party, each seller, each buyer, it's going to be 2.14%. Okay. If you're selling in like the counties, Bucks County, Montgomery County, Delaware County, it's 1% each party. So it's really 2%, but it's 1%. And if you sell up in the city of Reading, I think Reading is the highest in the state, and I think that's like 5%. So each half would pay 2.5%. All right, so let's say, there are exemptions, and we talked about some of these. If it's a religious group or an educational institution, if you're doing a petition suit and you bump somebody, out of the ownership of the property and you're redoing the deed, they're not going to charge you extra taxes on that.
Hey, Janet.
Yes.
So the transfer tax, is that the tax on the total sale amount, or I missed that point?
On the sale, yes, they do it on the total sale amount.
Hey, Janet,
Yes.
have you sold any homes like in Fishtown, Northern Liberties, any of these upcoming neighborhoods, where they're redoing the neighborhoods, where they have this 10-year tax abatement? Have you sold any homes over in that area?
Yes.
You have? Okay.
For 10-year tax abatements.
Mm-hmm.
They still have to pay the whole, that real estate transfer tax. But that would be for the homeowner. They still have to pay taxes on the land. They're just not paying taxes on the house. So, okay. It doesn't exactly have to do with what we're talking about, but this is what I'll tell you. The mortgage company is going to look at that. And depending on where they are in the 10-year tax period. So even though there's like 10 years, there's a 10-year tax abatement, we'll say, there could be 5 years left. So the person that's buying the house won't have to pay that real estate, the full real estate tax for that next upcoming 5 years. Now, let's say it's running out in a year. That might make a difference with the mortgage company, okay? because it looks like the taxes are really low. And if you remember, when you're selling a property, you know, a buyer is paying in their mortgage payment, they're paying for their principal and interest, they're paying taxes, and they're paying insurance. And so they approve them for a certain amount, like the maximum amount of payment that they're allowed to purchase a house for. Now, if you're calculating in the purchase and, you know, you're early on or, you know, close to the beginning, the bank goes, well, okay, the taxes are really low and they're not worried about it. But if it's going to expire within the year, they're going to make you, or they will calculate that full tax so that you're not going to get yourself, or your buyer is not going to get themselves in trouble. But that's something different, okay, than the transfer tax.
Okay.
Okay. All right, so we kind of did talk about this, you know, involuntary alienation already. You know, you're not voluntarily transferring. It could be a foreclosure, that would be one. Okay, adverse possession, that's not voluntary. Somebody has open, notoriously, and continuously taken over a property of another person, and they've either used it openly for a period of, in Pennsylvania, 21 years. They can decide to petition the court for ownership and have title of ownership transferred over to them. So when you're reading and you're going through this, take a look at this. We've talked about all of these. Person dies intestate, meaning they don't have a will. It goes to a cheat. The county or the, you know, the state takes it over. We talked about eminent domain, when a municipality decides, you know, they need it for the good of the public. They can, you know, exercise eminent domain, non-payment of a debt. Obviously in a foreclosure, you know, eventually if you're not paying your mortgage or you're not paying your taxes, they're going to come along and they're going to take that property off of you. Okay, transfer of a property by a will. Legal requirements for writing a will. You have to have, have legal age, sound mind, which would be, these would be considered capacity to be able to, you know, to make a will up, you know, signed by the testator, witnesses. Oh, this is, okay, when there's a will, if you're in the will and you're a notary, you can't witness that will. You have to get an unbiased, independent person to do a will. Yes, Pennsylvania does permit holographic. Transfer of title by descent upon intestate situation. Okay. Intestate, that means that there is no will. Transfer of descent would be, you know, I pass away, I don't have a will, and I have 2 children. My children will petition. They would probate the estate and raise the estate, and that the title to the property would transfer to them. Okay, by law. Probate to confirm will validity. Yeah, wills are registered with the Register of Wills. Okay, so there are terms on here. They're very basic terms. We should know this. Just give me 1 minute to catch up. Okay, so, you know, testate, intestate. We know intestate, person dies, they don't have will. Testate, they do have a will. Testor is the person that's making the will. The device is a gift of the real property. A devicee is the person that's going to be getting it. Bequest is, you know, giving away your property. Legacy would be considered your consideration or the money or whatever you're giving away. Probate, that would be the whole legal process of probating the estate, whether it's intestate or testate. An executor, this is what the differences are. An executor means there was a will, and an executor would be the person that is executing the will as a male. If it's a woman, it would be an executrix. An administrator means the person died intestate without a will. So the courts allow them, or not the courts, but they file, the documents that they need to file. And it's agreed to by letters of testamentary that they can execute on the estate, but there is no will. So they call them an administrator. If it's a woman, they call her an administratrix. Okay, court-appointed administrator. Normally, let's say there's a family, somebody agrees to administer to the estate, and if you're an executor or an administrator, you can actually charge the estate for probating. Okay, that ends that chapter. So we're going to go over the key points, which should just be a reiteration, basically, of everything that we just went through. And we will do the quiz, and then we're going to take a break. All right, I think we might get done a little bit early tonight too, which you should all be happy about because I know you're just all dying to study.
Yeah, right.
I'm excited. My book is arriving tomorrow, so that's a good thing.
Yay, then you can write all over your book the way I write over mine.
Yeah.
I feel like the book makes a big difference.
It does.
Okay, let me just tell you, when we're in normal times, okay, and we're in a classroom, it's easier, and we hand out the books. Obviously, to hand the books out to everybody, that would not be possible. I have both. I have an ebook, and I like it when I can sign in it on my phone, and I don't have the book around. But I still, and this is me, I like writing in my book. And if you saw what my book looks like, you wouldn't even believe it. Okay, it's got notes all over the place, underlining. I mean, it looks like it's pretty well beat up, actually.
It's an ebook just for instructors?
The ebook?
Yes.
Well, everybody has an ebook. Who's asking me
Okay.
this?
I asked you that. You mean,
William.
I'm talking about what you post. Right, I got it. I see what you're saying. Okay.
Okay, because if you don't have a book yet, that would be concerning.
Right, we've been, the one that you post, I got it. I don't know why I asked that, but I understand.
Okay. Okay, is everybody ready?
What I was saying is, you said you carry it, you listen to it and all that. That's what I was, didn't you say you listen to it?
Well, okay, you can listen to it, but you can do it through your phone, if you want to do that, right?
How?
I mean, this is me personally. I like to write on everything I do pretty much, right?
Right.
It just helps to keep me, I think, organized. But even when I have my PDFs, right? I mean, if you look at my PDFs are written all over them too. And so should yours be, right? Because when you're reading your book or you're going through things, you might want to make some notes to jog your memory or whatever. And I'll show you. You can see that I just write all over them. So eventually when you go to study for your, and when I do want to talk about this too, eventually when you go to study for your exam, you're probably not going to want to or have the time to go back and read every single page in your book, nor do you really have to, because a lot of this material you will remember. And so it'll be easy for you to do like your reviews by just going over your PDFs, right? Now, if you're going through your PDF and you get to a point and you go, wow, I don't remember what that means, or not sure, then you go to your book and you're going to want to look at it and understand it and then make a note on your PDF. Now, I did speak to somebody today and we were talking about the books, and they said, you know, that, and this is my answer, okay, that they were overwhelmed because they had to read the whole entire book and memorize it. You're never going to be able to memorize this entire book, and you're really not expected to, but you are expected to read it so that you have an overview and it makes sense to you, right? This book is 22 chapters, and if you think about it, there's only so many questions. Like, you're going to have a test next week, right, after you do chapter 12. That test is 55 questions, right? And if you think about the quizzes that are in back of each chapter, they're like 20 questions, right? If you're going through quizzes with 20 questions and then you have 12 chapters, that's 240 questions. You know, you're not, okay, and I don't want anybody to worry about this either, but you're not going to be quizzed on every single little thing that you're reading. Now, all right, I know I talked about this before. I'm going to talk about it again. Before you do your actual exam next week, there will be a review. The only thing I'm going to be reviewing is what is going to be on the test. Nothing more. Because if I was to review every single thing that was in the chapters, I would be there for at least another 3-4 days. That is not what's going to happen. What's going to happen is I will have the test. I will go through the test. I'm going to ask you the questions basically that are on the test in a reworded way, maybe with different examples. But basically, that test, when I'm doing the preview, is going to be very well gone over. So that will be done when we're doing chapter 12. I'm going to go over that with you. Now, the next class, you'll be doing the test. But before we do the test, I probably will go over where I think somebody might get stuck. All right, if it's a question that I think might be, maybe it's not real clear, right? Or there could be more than one answer, or, you know, something like that, we'll review it. Now, the other thing I will tell you is, and if this will be a time test, if it is, and you don't have enough time, and I'm going to give these instructions again next week, but if you don't have enough time to complete everything, I don't want anybody like to lose their mind over it. You just write down whatever question that was, question 10, question 12, I don't really care. And then text it to me, and I'm going to keep track of that. And if I see somebody texting me that they didn't complete 12 because they didn't have enough time, when, you know, and everybody's going to leave at different times. Okay, the ones that are left behind, I know they're left behind because they want additional time. I'm going to go back and give you the additional time so that you will be able to answer, you know, you'll be able to answer the questions. Okay, now, if for any reason you still don't pass the test, you will hear from me and I will review with you and I will say, you know, listen, you were only short like 3 answers. these are what the answers are. This is the reason why. Let's go over this. And then I will let you take the test again. So you will pass. I will make sure that everybody is going to pass and that you really understand the material, because the test is really, it's not meant to hold you back. It's not meant to make you fail. The test is to help you so that it's an evaluation of where you are. And if you need a little extra help or you need a push, you will get that, okay? It's not meant to intimidate you. It's not meant for you to lose nights of sleep. It's really meant to be an assessment. Oh, yes. It's not.
Yeah, we'll definitely use some sleep.
I know. It's a lot of material to learn in a very short period of time. It is. But where the test will help you is you're going to go, well, I wasn't really sure about that. I know we reviewed it, but I'm not getting it, or, you know, whatever. The whole idea is by the time you leave the class at the end of 22 and you do, you know, your final test and everything, that you will be prepared for the state exam. Okay. And I'm going to tell you that when you pass, everybody will eventually pass. When you pass, take your state exam as quickly as you can, because the longer time goes by, the less likely you are to do as well as you would if you took it right away. And then you're going to wind up 2 months, 3 months. And I get this all the time. Somebody will say, oh, I need more time to study. I need more time to study. But then they don't really study. And then, you know, they'll call and say, listen, I forgot everything. Can I get back in another class? Yes, Mark will let you back in another class. But if you can really pass it, try it. And maybe, you know, if you don't pass both sections, the fundamentals, you know, you'll pass the practice, or you'll pass practice and the fundamentals, whatever. At least try, and you might be surprised. But you do have to read the book. At least you don't have to, no one's saying to memorize the book. You have to read it to understand it. But if you go over the PowerPoint presentations and you pay attention during the review, you'll be fine. Okay? You really will be. You know a lot more than you think you do. So we're going to breeze through the Cuisinate, and then we're going to take our break. Okay? So 1, it is essential that every deed be signed by the devicee, grantee, grantor, and grantee, or the grantor.
D.
The grantor. The grantee never signs it. Only the seller signs it. A 15-year-old boy recently inherited many parcels of real estate from his father and has decided to sell one of them to pay inheritance taxes. If the boy enters into a deed conveying his interest in the property to a purchaser, such a conveyance would be valid, voidable, void, or invalid. It would be voidable because he's not of age. He's not 18 yet. A grantee receives greatest protection.
That's a trick question, though, you know, because it could, if he's not of age, it would be invalid too, right?
It would be, well, yeah, it wouldn't be considered valid, but the correct answer is voidable. But let me tell you, if a purchaser is purchasing, all right, a purchaser is going to settlement, the title company would never let this happen. But if you have, let's say my son is 14 years old and I pass away and he inherits the property. And let's say my long lost brother, an unscrupulous character, comes along and says, hey, I want to buy these properties from you, and I'm going to give you X amount of dollars. And he's a kid and he says, wow, that sounds like a lot of money to me. I think that's a good deal. the purchaser says, look, I'm going to, have the deeds drawn up and we'll go to a notary and, I know this notary, we'll get this filed and, we'll get the deed recorded. Well, now the kid comes of age and he's smart, right? And he's saying, well, wait a minute, this guy took advantage of me. He does have grounds to have those sales voided, right? We know it's not a valid sale. It's not a void sale because it hasn't happened yet. And you could argue it'd be invalid, but the bottom line is it's a voidable contract. It's not even a valid contract, honestly, but it's certainly voidable. It's happened. So now he does have legal recourse to go back and have it voided. All right, so the grantee receives greatest protection with which type of deed? Was it a quit claim, a bargain and sale, a general warranty, or an executor's?
C.
C. Which of the following best describes the covenant of quiet enjoyment? The grantor warrants that the grantor is the owner and has the right to convey title to it. No, that was season. Oh, okay. Let me just ask you. The grantor guarantees that the title will be good against the title claims of a third party. The grantor warrants that no mortgages, mechanics, liens, or easements affect title to the property being conveyed, or the grantor promises to obtain and deliver any instrument needed to make the title good.
B.
Yes. Which deed would be most likely to recite the full actual consideration paid for the property? A deed in trust, a gift deed, a deed executed pursuant to court order, or the trustee's deed?
C.
Yes. Okay, which deed merely implies but does not specifically warrant that the grantor holds good title to the property? Is it a quitclaim deed, a special warranty deed, a bargain and sale deed, or the trustee's deed?
C.
It is C. So you have these definitions on your PDF slides. You have pages that explain each one of them independently, and then you have one where they're all listed, kind of like almost like a cheat sheet. You can just look at the one page and review it. I suggest go and just look at your little cheat sheet there that has everything on there, and then if you want a further explanation, you can go back to the full pages. Okay. All right, the probate court will distribute property held A, in joint tenancy with a brother, B, in tenancy by the entirety with a spouse, C, in severalty by the deceased, or D, by creditors. Okay, now the operative word in that would be probate.
Is it A?
No.
D.
A.
Okay, what has to happen in order for a property to be probated?
Someone has to die.
Yeah.
Right.
That's a C.
Somebody would have to. So what do you think it is?
C?
A.
C.
It's C. Okay, in severalty by the deceased. How can property be voluntarily transferred to another party? With a deed, by court action, by adverse possession, or by the sheet?
A.
By A.
Right, it would have to be voluntary. So B, court action would not be voluntary. Adverse possession is not voluntary, and a sheet is not voluntary. You got to look for these little keywords in there. And in that situation, the keyword would be voluntary. A woman bought acreage in a distant county, never went to see the acreage, and did not use the ground. A man moved his mobile home onto the land, had a water well drilled, and lived there for 22 years. The man may become the owner of the land if he has complied with the state law regarding what? Is it adverse possession, voluntary alienation, avulsion, or requirements for a valid conveyance?
A.
A, adverse possession. So in there, well, there's a few keywords in there, but you see 22.
22 years.
Okay, that would be the first one that would stand out for me, right? Generally, where does a probate proceeding involving real property take place? In the county in which the executor or the beneficiary resides, only in the county in which the property is located, in both the county where the decedent resided and the county in which the property is located, or D, only in the county in which the decedent resided.
Let's see. That's easy.
Yes. All right. An owner of real estate was declared legally incompetent and was committed to a state mental institution. While institutionalized, the owner wrote and executed a will. The owner later died and was survived by a spouse and 3 children. The real estate will pass. Is it to the owner's spouse, to their heirs mentioned in the owner's will, to the state, or according to the state law of descent?
B.
What is it?
I said B.
It is D, because we know that he wasn't capable of having a valid will because he was, not of sound mind. In order to do a will, you have to not just be of legal age, but you have to be of sound mind. He could will it to whoever he wants, but that will could be broken. That can certainly be contested. So the spouse wouldn't necessarily get it unless they bought the house together and it was by tenants in the entirety. Then it doesn't matter. It automatically, upon the spouse's death, would pass to the spouse. But if they didn't take deed, let's just say the husband owned it, he passes away, but he never put his wife on the deed or he added it later, but not by tenants by the entirety, the will is meaningless. It would go to, the state law, whatever the state law will allow. What will happen to the real estate if the deceased owner did not write a will and has no heirs? The property will revert to the previous owner. The ownership will escheat. The ownership will pass by device. The courts will seize the ownership. Died,
B, right?
no heirs.
Escheat. B.
The deed states that the grantor, who is the seller, is conveying all rights and interests of the grantor to have and to hold by the grantee. This is the clause of restrictive clause, covenant of seisin, acknowledgement clause, or the habendum clause.
D.
Is that B?
Yeah, it certainly is D. We know it's not a restrictive clause, that there's no restriction there, right? A covenant of seisin, that means that, the right to convey the property.
Yeah.
Acknowledgement clause is where somebody, acknowledges that, they're selling the property and they're selling it legally and there is sound of minds and all that, and it's notarized. So it's the habendum clause. The deed that grants and releases and implies that the grantor has title to a special warranty deed, trust deed, quitclaim deed, or bargain and sale deed. That's all. There's no warranties or anything, right? It just says here,
Bargain and sell?
bargain and sale. Doesn't say anything, warranties or, the highest degree of passing a property on. Very simple. That's all it is. Bargain and sale. Which of the following is an example of involuntary alienation? Having a piece of land sold for delinquent taxes. Involuntary, by the way, is the key word. Okay, letting another person plant crops on an unused portion of a piece of land. Selling a property to pay off debts. Or giving a piece of land to the zoo.
It's A.
A grantor does not wish to be responsible for defects in the title that arise from previous owners, but will guarantee the title to the time for the time the grantor has the ownership. What type of deed would the grantor convey? They're only saying, okay, that, do you remember when we went over the deeds, the highest would be the general warranty deed, because it's during your ownership and all ownerships prior to you going back to origin, right? The next one that we talked about basically had all the same covenants, but for one. And it said it protected them during the person that's selling it, their ownership, but not going back.
So that's special warranty.
Yes. Which of the following is an involuntary alienation of the property? Okay, involuntary. Inheritance, a gift, adverse possession, or quit claim.
Is it C?
Adverse possession.
Yes, that's really the only one. A single person owned a parcel of land, and subsequent to the owner's death, the probate court, and we know why we use probate courts, right, determined the distribution of the land in accordance with the state's statutes. This person died testate. Was the grantee, was the devicee, or died intestate?
D.
Intestate.
Yeah. Normally, a deed will be considered valid even if A, the grantor is not a legal entity, B, it's signed by an attorney in fact, or a power of attorney would also be an attorney in fact rather than the seller. The grantor is a minor, or the grantor did not deliver the deed.
Is it B?
B.
Yeah, when somebody has a power of attorney, and I just had a settlement this week where the person that actually was the seller is in a nursing home. She's still alive, right? But she has dementia. And she's in and out of dementia. So she wouldn't really have legal capacity. Her son has power of attorney to execute all of her affairs, including the demise of her real estate. However, it was very interesting that the title company accepted the power of attorney. But the day we went to settlement, okay, the title company had to call the nursing home to make sure she was still alive while we were settling. And the reason is, even though the power of attorney signed all the documents, let's say that morning something happened to her and she passed away. That power of attorney dies when the person dies, right? And so that would not have been a valid power of attorney any longer. Now we would have been talking about my historical buyer and the fact that that whole property now had to be put into an estate, had to be probated, and all these other things would have had to happen before my client would have been able to buy the property. So my buyer said to me, I'm not sure if she was joking or not, but the lady in the nursing home, her name was Joan, and she said to me, Janet, she said, every night before I go to sleep, I pray for Joan.
Oh my God.
And she would say this to me and I would laugh. But, you know, I would think to myself, I wonder if she's serious or not. I still don't really know, okay? I do think she might have been praying for her, though, you know? And I would just say, oh, yes, God bless Joan, you know? But anyway, yeah, in that situation, it would be an attorney in fact or power of attorney, basically the same thing. A person died intestate. He left behind a wife. In this situation, who inherits the property? The state, the county, his church, or his wife?
His wife.
His wife. Right. Okay, so that ends 20. It is 8 o'clock. So come back. Well, you're entitled to take a half an hour altogether for a break. So come back at 8:30. Okay.
Yes.
All right, and you should still be getting
Sounds
out early. Okay. See you in a half hour. Following me in the book, it begins on page, let's see. Well, 139 is where I would start. It's a very short chapter. We should breeze through it, and then we'll do the quiz, and then you will be getting out early. Okay.
You said 139?
139. Unit 9. Okay, so what is going to be important in this chapter really is going to be understanding what public records are. Also, what's involved with a title and title insurance. Okay, so contain crucial information to establish ownership, give notice of encumbrances, and establish priority of liens. When you go to a settlement, the documents, okay, for a property, there's going to be a history that will go all the way back to the origin, but you'll see recorded in public records when they're being searched. You're going to see mortgages that have been satisfied, open mortgages. You're going to see deeds that have passed from one owner to another. In public records, you're going to see, along with the mortgage, there'll be notes. There will be another form of public records is if there's any outstanding liens, if there's any judgments, are there any okay, municipal, well, that would also be a municipal lien. Everything is searched. They don't leave anything unturned. Okay, and what they're trying to do is they're trying to establish that the person that's selling the property has legal ownership, and that when they purchased it and there's no defects in the title. They're looking for any kind of an encumbrance. It doesn't matter. An encumbrance could be an easement. It could be, you know, any judgments, special assessments. They would also be considered encumbrances. So the purpose of it is to protect the interest of real estate owner. The taxing bodies could be tax liens also. Creditors, anybody, you know, that has an attachment, a judgment to the property. And it's also meant to protect the general public, people that are looking to purchase a property. We have the real estate recording system, which includes all these written documents, titles, titles such as deeds and mortgages. They're all public records. And if you wanted to, well, not right now because of the virus and everything, but during normal times, if you really wanted to go and do research on a property, you know, you can certainly do that. And if you remember the story when I was telling you that during a sale, I saw, well, I would believe that part of the house was on another lot, another property. Well, yes, in fact, it was. So I went and searched the public records physically, drove up and went to the recorder of deeds. And, you know, I was like pulling everything, and I was following that whole chain of title to see who currently owned it, who owned it before them, and who owned it before them, until I put the story together and I could see what was really going on. You would not normally do that. There are searchers that do that. It would be unusual for you to do that. But can you do it? And the answer is yes, because everything is recorded. Now, there are some things that could be recorded at the township level, and some things that will be recorded at the county level. So when you're doing a search like that, more or less it would be at the county level. Now, as an example, I have a lot that I'm going to be selling, but it's really not exactly the most desirable lot in the most desirable area. So over the weekend, I went up, took pictures, but what I also did was I drove around because it's in a commercial area, and I wanted to see, well, okay, what kind of businesses are around there? And I took information on the businesses and all their phone numbers and all that. That only gives me part of the information. Now, I know that this lot had a house on it. And I also know there was a variance which turned it into a residential lot. But my client hired a company and had the house torn down. And so I look at public records and it's saying and showing pictures that there's a house on there. I know there's no house on there. So now what do I have to do? I have to go to the township and have them pull the file to see, is the public record just wrong, or did the company that demolished the house, did they take a permit out to do that? I mean, I have homework to do. Then at some point I'm going to have to go to, well, it depends. If they have the records that I'm looking for at the township level, I will stop there. But if it's more than that, then I'm going to have to drive up to the courthouse up in Doylestown, and then I'm going to have to go and have additional records pulled. I'm just looking for information because I know at some point, hopefully, I will have a buyer, and the buyer is going to want all this information. So I want to pull the plat plans. Part of the reason I want to do that is because for the businesses that are in the area, I want to see who actually owns these businesses, because I want to contact them and I want to see, when I'm looking at the plat plan, what businesses actually touch the boundaries of this particular property. Now, if I'm looking more to the legal aspect of it, I could go up to the courthouse and pull those records as well. I'm not really that concerned about it because eventually when you have a buyer, the title company is going to hire people to do that. So I don't feel that that is a necessity. But the point is, all this information is public records that anybody can walk in and you can ask for this information or ask them to point you in the right direction so that you can search this all for yourself. Okay, the act of placing documents in public records is recording. So anytime you go to settlement and there is a sale, those documents are recorded. And so it will be available to anybody at some point that decides they need information for, you know, a specific reason. Now, my reason is solely just, as a realtor, because I feel this is what I need to do my job properly. There could be other reasons why this is done. Maybe somebody wants to sue somebody, or for me, I'm looking at other records because I want to find out who else has ownership. So there's all different reasons why people want to search these public records. But anyway, written documents provide ability to discover various interests in the property, and that is what they consider to be serving as a public notice. Recording laws are state specific. Now, I am going to tell you, with that being said, who takes the longest time to file these records is the city of Philadelphia. I can tell you that when I sell a house, and this is what is interesting to me, when you sell a property, part of selling the property, the title company is going to provide notice to the water department so the water can be transferred into the new owner's name. That can take months. And so while that's not happening, but it's in process, the person that has bought the property and that is living in the property is getting bills in the old owner's name, although it's their water bill. So, all that has to be explained to them. So you're going to see, even though there are state laws on how to file, it's more like specifically time period. It can take quite some time, and now trying to get anything because of what's going on, it's just, yeah, it's very trying. So recording asks give priority to those interests recorded first. And it's the same thing, first in time, first in line. Remember, written documents related to land must be recorded in the county where the property is located. Well, that's kind of common sense. Okay, so this is where you have a difference. There's something that's called constructive notice, which means it's just assumed, presumed, or you should have known about it because the information was available there for you to know about it. Actual notice is you actually received notice. Somebody put it in your hand, or you had direct knowledge of something. So legal presumption. If a document is filed, there's a legal presumption that the information was available, so therefore you had constructive notice. A prospective buyer or a mortgage lender is responsible for this discovery. So when your buyer is looking to purchase a property, he basically has constructive notice by knowledge that these records are public, and the title company then searches. They have abstractors. They go and they search these records. And so a copy at some point will be given to the buyer in the form of, a title report. Now the buyer has it in hand, they're visually looking at it. That is an actual notice, okay? So that's where it can go from a constructive notice to an actual notice. So information is available and someone's given the information, actually knows of it, direct knowledge, prove actual notice, and another person can't use lack of constructive notice to justify a claim. They actually know what's going on. And let me tell you, when your buyer hires a title company, they look through everything. Can something be overlooked? Yes. If something happened and maybe it wasn't filed in time, there could potentially be a cloud on the title, which is why when the buyer is having a title company do their title report, these are really reviewed documents. The title report is done. An abstract is all this information pulled together into a summary, an abstract. The title company okay, provides all this information to a title insurer who has attorneys. And these attorneys review all these documents, and then they will give an opinion on it. Now, sometimes that opinion, right, they're saying that at this point, maybe that they cannot insure this particular title. And the reason is because there's something lacking. Now, this one sale that I just had when I was telling you about the power of attorney, that's what happened. It was an attorney's opinion that they were not happy with this power of attorney that was given to them. So the seller actually had to get additional documentation and proof that these parties are, or, you know, were who they said they were when everything was signed. They had to get a statement from the actual notary, and it had to be filed at the courthouse before the sale actually took place. And then proof had to be given to the title insurer for the attorney to review it to make sure that it was done correctly. And then they issued the title insurance policy. So, you know, can these become a little complicated? Yes. Is it your job to do all this work? No, the title company will do this work, but you will get a copy of it. And if you have any questions about it, you can always go back to the title company and say, listen, I don't understand this, or what about this? And I can tell you, there are times that I do get these title reports and it'll say, see attached judgment. And I just keep reading the report and there's no judgment there. And so what I need to do, then I go back to the title company and say, thank you for the report, but I need a copy of all the judgments. And the reason I do that is this: there are people that have very common names, and maybe the only thing that's going to differentiate them is a middle initial. So if my client's name is, let's say, James, I don't know, P. Smith, well, it's going to pull up James Smith, James A. Smith, James D. Smith, James R. Smith, okay? Then I have to, especially if I have the seller, I have to call up my client and say, what is your middle name? You know, I go through everything. Was this your judgment? Did you ever live at this address? And, you know, no. So when we go to settlement, the seller is going to have to sign something that says, you know, that he never lived at this address, that this was not him, that his middle initial was never, you know, known as A. And, you know, so they make them sign this so that if there's any lying or fraud or whatever committed, then it kind of takes the responsibility off of the title company, and the buyer can go back to the seller. Okay.
Hey, Janet.
Yes.
Question. So you couldn't use your buyer's social security number to dig up those records as well, or is it only name?
Sometimes, yes, if the social security number is on there, but sometimes there is no social security number that's on there. Now, I'll give you an example. My buyer had a judgment. Well, nobody knew what the judgment was for. Okay, I got like an abstract of it. All right, so I had to, and this is where it gets interesting, okay? I went and I pulled the public records on that particular judgment, and then I got the additional documents and I kind of pieced it together. Then I called my client initially when I said, do you have any judgments against you? And no. Now, my next conversation, because I went back and I did this, was, did you ever receive Social Security? Yes. How long ago? Well, it's been X amount of years ago. Did you ever live at this address? He goes, yeah, I did. And I said, okay, when you were living at that address, how long ago has it been since you've moved there? Well, he moved from that address before the judgment was filed against him. So he probably really didn't know about it. Okay. Then I said, okay, we got to make sure that this is all fixed. Otherwise, you're not going to be able to buy this property. And so, I helped him with it. It was daunting. Okay. There are just times that, you're going to follow up on it because the title companies, as good as they are, they could be really busy. And by the time they finally sort it out, you could have been like long done with it. Okay.
Janet, isn't this information public information? Like, can't you pull up title and deed and all of that in public information?
Well, okay, yes, but, okay, I'm giving you an example. This is something that was on the title report. Okay, so the title company, they saw a judgment, but they didn't know whether it was my client or not. It was just a judgment, and the name was basically the same. But on the same paper, there were other judgments too that were not his. So when you're a realtor and you're representing the seller, that can happen. Then you got to ask your seller these questions. Is this, is this you? Is this your judgment? Did you ever live here? And you got to sort through all that, because there are a lot of common names out there. And maybe the only thing is going to differentiate them is something like a middle initial, or if you're lucky, there's a social security number or some other information, that would be out there. Okay. Another example was somebody that was selling their house, and they pulled up a judgment, but it was the person's name, but a different address. That did have to be paid, but then I had to go back and ask my client, all right, and she's the seller, remember, of this one property, but this judgment was on something totally different. And so, I called her up and I said, listen, I know you're selling your house at, and I said, but there's a judgment at this address. And, I said, is this you? And the answer was yes, but it could have been no too. The title company isn't going to sort through all of this for you. They're going to expect you as the listing agent, right, to go back and have this discussion, with your client, and then, just show proof, right? So tele reports, they are important. If you're representing the buyer, and let's say your buyer is buying a property, and all of a sudden you're looking at this and you're going, oh my God, what is going on here? There's a lot of judgments here and everything. I hope this seller has the capacity to be selling this house because we're really into the sale. Now, I would say the majority of time, the other agent knows about it, but they never say anything. And I had a situation where I'm trying to figure out the numbers on the seller's end. And I called the realtor up and I said, listen, I'm a little bit concerned. And I explained to her why. And I said, as far as I can figure this out, I think your client's going to be short. But she knew about that. She said, yes, he is going to be short, but he's going to be bringing money to the settlement table. Okay, then, as long as, he's going to be selling the house and these get paid, that's all I care about. You can't not look at this and just start assuming things like, oh yeah, the title company, they're going to figure this out. Hopefully they will, but they don't always. So it's up to you to, fact check, or at least to call the title company and say, hey, I noticed that there's like 10 judgments on here and, I'm freaking out. Are you removing these judgments, or, are you doing this, or, do you expect me to do it? Or, you got to have a communication with them and ask them. So if I see something that is on a title report, I always follow up on it because I don't like last minute surprises. If there's an issue, I want to know about that issue early on. I don't want to wait until I go to settlement and then be sitting, or it's a few days before settlement, and then all of a sudden, you know, I find out all this information. So on the title, it could be something that is against the buyer. It could be something that's against the seller. If I'm representing the buyer, I think I have an obligation to ask the seller, you know, the seller's realtor if everything is going to be okay. Now, if I'm representing my buyer, then I got to, you know, follow up and, you know, ask these questions, okay? It could have been that that unemployment lien had nothing to do with my client. I would not have had a way of knowing that unless I actually did ask. And to get those documents during COVID was almost impossible. My client actually rode out to Harrisburg. He drove out there only to find that there were security guards there. Nobody was even working in the building. They were all working from home. And so the documents that we really needed, he himself wasn't even able to get. And he said at one point he had a password and a username to get into, to pull some of these documents or to help us, but he couldn't even remember, because it was so many years ago, what his username or his, you know, what his password was. And so we had our attorney trying to get in touch with them. And I mean, I even got to the point where I went on LinkedIn and I was asking, is there anybody that works at the unemployment office, you know, and whatever. And I did have one or two people that answered and kind of helped point me in the right direction. Anyway, so that's what the difference would be. All right, so okay, so priority, who recorded first? Just because somebody recorded first doesn't mean they have top priority. Who had possession first? Probably that would make a difference. Who had actual or constructive notice may make a difference. But all are legal questions that should be referred to parties' attorneys. Now, my company does have an attorney. He sits in our office. Can never get him on the phone. He may or may not answer your email, but if I really had a question, I would drive to the office, walk into his office and stand in front of his desk, you know, because they can get very busy. And I don't bother them unless I really need to. So if you see me standing before your desk, you know there's a reason why I'm there. And so something like that, if I thought there was really a legal issue, I address them really early on. I don't wait until a problem, you know, is a real problem. Okay, unrecorded documents. So we have certain liens not recorded, but they may have priority, and that could have to do with taxes, even inheritance taxes. You may not even see inheritance taxes filed. You could, but probably you wouldn't, especially if it's an estate and somebody recently died. And that's why the title company, they will do a holdback to make sure those, not only that the inheritance taxes were filed, but that they have a letter from the state saying that the taxes that were filed is acceptable. And that is the reason why, because they don't want to be held responsible for these inheritance taxes. And I can tell you, if somebody passes away and the inheritance taxes have been filed, it could take them 6 to 9 months before they get a letter back from the state. They want to sell the house in the meantime. So then, if I'm taking the listing, I will tell them up front so they know what to expect. Otherwise, you know, they're going to be upset. And I'll say, listen, I know you filed your inheritance taxes and I'm sure everything is going to be okay. However, the title company, when we have a buyer, they're going to ask you for the letter from the state. Well, they don't even know what you're talking about yet. And I'll say, well, because you don't have the letter, what they're going to do is I can present to them the information, the form showing, you know, the inventory, showing this, showing that. But at the end of the day, they're still going to want to hold back money until you can provide them with that letter. And when you do, they will release the money back to you. So it's only, temporary. Or maybe not. It depends, Maybe they do owe some extra money. Then, maybe it's for, a lien, and now there is additional costs that have been incurred. So the money will be there before it's parsed out to wherever it needs to go. So, yeah, there could be unrecorded liens. That's possible. All right. The other thing too is when sometimes I will get the title and maybe I don't have what I'm looking for there. They haven't received the tax certs back yet, showing what the taxes are and that they've all been paid or not paid. They don't have the utility certs back yet, right? So I'll make a note to myself, and maybe a week later, I'll start sending them I'll send them an email saying, did you get the tax certs in or utility certs in? Now, this is something that I use that helps me. It's a service called Follow Up Then. Okay. So as an example, I will send an email to the title company. And in the BCC, I'll put in there 1 week at FUT.io, which is 1 week at Follow Up Then. It's an abbreviation, and IO stands for in and out. So what happens is a week later, right, I will get an email back, and sometimes I just put, 9 a.m. 1 week. Well, a week goes by and I get a reminder automatically sent to me, and same email. So I don't have to guess why this is coming back to me. And I said, oh yeah, you know what? I haven't heard from that title company. What are they doing? So I might do another follow-up, but now I'm going to do it for 2 days. And if I still don't have it, I'm going to call them on the phone and say, listen, I've been asking for over a week now for those tax certs. Is there an issue here? I mean, did they come in? Or if they didn't come in, when are you going to have them? All that's going to be needed. That's all part of that whole title search thing. Now, it doesn't matter whatever title company I use. I think they get really busy, and your priority is not always their priority. And this is something you'll hear. Is title in? Yes. Can you send it to me? No, it's in typing. All right. Oh, okay. I'll wait a day or two, and I expect to have it in by then. But the point is, all these documents, they are recorded. Everything is searched. Liens and judgments are searched with mortgages. I had a sale not all that long ago where there was a break, in the chain of title. And so that had to be clear. It wasn't the chain of title, it was on a mortgage. But the mortgage was never satisfied. But the mortgage was also we'll say a mortgage 50 years ago. First of all, the mortgage company wasn't even in business, and it was a 30-year mortgage. So I asked the title company if they could get a letter of indemnity. And basically, that is a letter that is issued by the insurance carrier saying, yes, basically it's safe to go ahead, with the sale. They would indemnify it because obviously, if it's 50 years ago and it's a mortgage, the people weren't even alive. Oh, and actually that was another thing that happened recently. The seller was married and had writer survivorship, but nobody could prove, and that's jogging my memory, something I have to do. But anyway, nobody could prove that the husband died, okay? And now they were telling me, oh, we have a problem here and there and blah, blah, blah. I actually signed on to and joined Ancestry.com so I could do the research. And then I signed up for newspapers.com, right? This is all really the seller's responsibility. I have the buyer, but my client wanted to buy the house. The seller's agent at some point just like drifted away and fell apart on me, and she was saying, this is not my problem, and you know, whatever. It really should have been. But I'm just saying to myself, you know what, I'm just gonna figure this out. And so what I did was I was able to get photos of the grave, the date of death, where, you know, where they were, what funeral parlor they used, and I got, what else did I get? I got a copy of the obituary. I pieced this all together and then send it to the title company with an email saying, you know, here is proof of death and, you know, blah, blah, blah. Would you forward this on to the attorney for the title insurance company and ask if this is sufficient and, you know, as proof of death? And it showed in Ancestry.com when they got married, when he was born, when they, how many children they had, and every document supported the other document. And the title company said, yes, we will accept that as proof, right? I spent a lot of time and my own money doing that. Now, would the title company to go to that extent? Probably not. They didn't seem like they were doing anything above other than saying, oh, the seller has got to provide us with. And when I spoke to the other agent, she was just like, I'm so stressed out about this. I can't, this is not my job. And yeah, can that happen? It can happen. So the answer is yes, the information was all out there, but you know, it just needed to get done. Okay. All right, special assessments. They may or may not be filed. I sold a property not that long ago and there was a special assessment. However, the city wound up paying for it, which I thought was really odd, but it was not filed either as a lien. So we had a notice of it. I was aware of it. We contacted the city, who acted like they could have cared less about it. And, you know, the sale just went through. So, let's see here. Yeah, utility companies, they do want to get paid. And let me tell you, you're not paying your water bill, you're not paying your gas bill. That will come up as a judgment, and that does have to be paid at settlement. And not only does it have to be paid, but that usually the title companies are pretty good on following up on. Now, I kind of talked about the chain of title. Let me explain to you what it is. We'll start with that. So there is a deed, okay? The deeds are recorded and they have book and page numbers, we'll say, or, you know, identifying information. So it will say on the deed, in the description, you know, property that was previously owned by and sold, you know, and granted to, you know, the grantee on such a such date, and record it in book and page number. Then you would go back, look at book and page number, and then pull up that deed, which will lead you to the deed before that. And you go through that legal description and the deed before that. You're not doing this, by the way, okay? I mean, you can see it on a deed, but the abstractor who is doing the work will wind up doing that whole chain of title. So there could be a gap or a cloud somewhere. It could exist where it says here, must be clear by court action called suit to quiet title, and that is the seller would need to do that, to go to court just to say that, you know, the chain was broken, but, you know, maybe they want to get quiet title. I've never seen this happen on any of my sales. Okay, just so you know, but it could happen. Mortgage companies, they go way back, and I'm going to send you a deed on this one property where I'm telling you, it had every single party that was listed in sales transactions going all the way back, I think, to the house was built. And it was, I just found it to be really interesting the way it was written up. Okay, title search and abstract of title. So you have an abstractor who is going to examine all public records. Yeah, they start with the current owner and then they go backwards. Title traced back to the origin, which could be 40 to 60 years, could be more. Okay, but legally, I'm sure that the whole mindset there is they're going to go back maybe 60 years and they figure, well, if somebody else had ownership rights 60 years later, I mean, they would have figured it out at some point. A summary report. It's called an abstract of title, and basically it's just the summary of all the information that has been found. Okay, players in the search, you have the abstract of title, which is usually only like 1 or 2 pages, right? It's the information on your title report where that information comes from, and that comes from the abstractor who is doing the research. An attorney's opinion of title. So you'll have the title that's being requested, and then it goes through the process. Eventually it winds up at the title insurance company where it's reviewed by an attorney, and then the attorney will give his opinion as to whether or not that, you know, they consider this to be a marketable title. Okay, so the abstractor, that's the person. Abstract of title is your summary. Attorney opinion of title, we just talked about that. Marketable title. Okay, so what's considered to be a marketable title is a title that can be passed on to the buyer at the time of settlement. Okay, and we're going to go over this. All right. So the seller is supposed to be conveying over to the buyer a marketable title. Can it have defects in it? Yeah, I mean, what they would consider to be a defect would be maybe there's some kind of restriction on it, or a covenant restriction, something. In New Jersey, when I was selling that one property, and it had restrictions because there was like grant money, and that those restrictive covenants are on the title and will last for 30 years. So if my clients at some point go to sell that house, that will come up. It's a restrictive covenant that will come up when they start doing title searches. Now, I may eventually sell that house, and if I do, I would market it so everybody knew it was all disclosed. They know that there's going to be a limitation on the title. It's still a marketable title, but the buyer has to agree to purchase that house with the remainder of years that will be listed on that title. Now, it says here, can't force the buyer to accept as a defective title. That's true. However, if this is all disclosed and they know about it and they're okay and they're qualified, right? That particular property, the title on that property will still pass. It's not going to be a big deal. Now, if I never told anybody about it and it comes up, the buyer could turn around and say, whoa, wait a minute, this was never disclosed. We don't agree to these terms. We're not buying this property. you know, it's the same thing. And I'm going to tell you, you make sure that, you know, you disclose. Okay, so once a buyer accepts an unmarketable title, only legal recourse is to sue the seller under any covenants of warranty in the deed. Seller may need to reimburse the buyer for title preparation. So if I was selling a property and I know that there was a restrictive covenant or there was something on there, I probably at that point would ask minimally our attorney at the office, okay, to write something up, an acknowledgement that, you know, they understand that they're purchasing a property and there's a restrictive covenant and et cetera, et cetera, et cetera. The title company will also want something in writing. And more than likely, the insurer is going to want to see something in writing. And everybody's going to do this to protect themselves, okay? And the buyer, if they know ahead of time and they think they're getting a good deal, they don't really care, okay? So the house will sell in a really nice area below market value. They would be getting a good deal. So I don't see why somebody wouldn't want to buy that particular property. Although it might not be for everybody. Okay, so to be a marketable title, there's 4 rules that need to be met. No serious defects and no doubtful question of law to prove its validity. No, not expose the purchaser to hazards of litigation. Convince a reasonable informed person that he or she could sell or mortgage later, which everybody would expect, and be insurable by a reputable title insurance company at an ordinary rate. Now, if the person is buying that property and they have title insurance, when they go to sell it and nothing has changed, the title company that is doing the new title might do a look back at that policy just to make sure that, you know, everything looks okay. When I go to settlement, and I know I did mention it to you, I always ask the title company for a marked up title. And a marked up title just means that the title company has agreed, that particular title company has agreed to remove these liens, judgments, encumbrances, either because they did research and found that it had nothing to do with my client, or because there were judgments and the judgments were all satisfied and paid for at the time of settlement. So I scan them and I keep them in case I ever need to refer back to them. And the only time I really refer back to them is if I sell somebody a property and they call me 7 and 8 years later, which happens, and they'll say, Janet, do you remember me? Yes, of course. And they'll say, listen, you know, we want to sell our property. Do you think, you know, you might want to help us with that? Sure. I will at that point go and look at their old, and I keep everything. I will go back and I will look at that. Well, now they're called CDs. They used to be called HUDs. So if it's an older sale, I would go back and look at that. And I would see, well, what did they pay for it? What were their costs? I would look at the title to see, did we have any issues with it? And then, you know, I would go on the appointment and I would say, okay, well, I pull the records and you bought the house back in da-da-da-da. Your house is now worth probably around da-da-da-da. And I remember when we were buying the property, you know, there were some judgments that had to be cleared, but, you know, you should be fine. The title was marked. I have it here. All these issues were removed. I went back and I looked at the title and I see where they were paid. Okay. Now, if I've never had to use them though for a legal purpose, but I still ask for a marked up title. Proof of ownership. Okay, a certificate of title and then the title insurance. Well, okay, so we basically talked about part of this at least. All right, so let me pull up the rest of this. Okay. Okay, so the certificate of title is the statement of opinion regarding the title status of the date it is insured or issued. Now, I can tell you, I sold a property recently, and the title report, when they did the abstract, it only went to a certain date, which was like 2 months before I'm going to settlement. And I got in touch with the title company. I said, wait a minute. Okay, this covers my client up to 2 months ago. Well, what happens in the meantime? And they said, no, we're going to do a bring down and we're going to update it. We just haven't done it yet. Okay, right? So I do look at them and I look for dates just to make sure they're fairly recent and not 2 months old. All right, so the certificate of title, which is also known as the title insurance, okay? It's not a perfect document. Could be missing unrecorded documents, liens, defects, such as forged documents, incorrect marital information, incompetent parties, minors, fraud. There's no defense against the above defects since they are unknown. Certificate preparer is liable only for negligence in certificate preparation. Now, that is why the title company at the time of settlement will ask, are there any liens that recent liens that you've taken out that have not been recorded? I mean, all these questions are asked, and they will make the seller sign that the information that's on the title report, is accurate. Okay, in Pennsylvania, certificate of title is ownership proof, and they will get that at the time of settlement along with a copy of the deed. Remember, the deed by itself isn't sufficient ownership evidence. You need the certificate of title, and you will always be given that. Title insurance. It's a contract under which policyholder is protected from losses and title defects. Insurability determined by reviewing of the public records, covers events before the policy was issued. If there's something that happens afterwards during the owner's time there, that's on the new owner. It's not insurance that goes in like your homeowner's insurance. This is for anything that happened before the purchase. Okay, after record examination, preliminary report of title or commitment to issue a title policy is issued for the policy. Now, there's certain things that will be included. When you see your title insurance, there's going to be obviously the name of the insured, the legal description of the property is going to be on there, the interest that in the property, the conditions and any stipulations, and a schedule of all exceptions, including encumbrances and defects found in public records and any known unrecorded defects. So it'll include in there, any encumbrances, whether they're legal or easements. That's all included in the report. Okay, and there are two types of title insurance. There's standard and then there's extended. Now, the extended obviously is going to cost your client more money. So it's going to be all the standard protections that they get from from standard up above here, and then it's going to add into it plus things that are discovered by inspection of the property, like a survey or any unrecorded liens. I normally just recommend to my client, look, just take out the extended coverage. It'll cost you a little bit more money, but it could be worth it. Although I have to say, I've only heard of there being an issue, really, and it was a serious issue, one time since I've been doing real estate. And what happened was the title company, the person that owned it was embezzling people's money, and they were trying to stay afloat when that whole market, was crashing back in 2008. And so they were kind of like taking money from money that was coming in and then paying out money and, whatever. I don't know how they found out about it, but I guess it was on a state level, they found out about it and they were starting this whole investigation. And it was a lady who I really liked her, but, she was in over her head and she wound up just committing suicide. It was like major shock. And so I was contacted and they wanted a list of every single transaction that I had within the last few years, which I had to come up with. That was not a problem. But what they had to do was they had to sort through it all to see who was paid, who wasn't paid, and, who was owed money and all that. And then the people's title insurance, they were compensating to make sure that, when a person was buying the house, that the mortgage company was actually paid and that they actually had a clear title and all that. That's the only time I've ever really seen something happen. It was very stressful, and sad. It was a very sad thing to go through. All right, so title insurance, what it won't cover. It won't insure a bad title or give protection for clear defects appearing in the title search called exclusions. Examples of non-covered items will be zoning ordinances, restrictive covenants, easements, certain water rights, and current taxes and assessments. You remember the story with that house, and there was that, water right, the riparian easement that was under the house and all that. Even though that was filled in and it was no longer, in my opinion, a water right, but the state, they had something filed and that had to be taken care of. If I had sold that house to my client the way it was, and at some point she goes to sell it and it comes up, she would not have had any legal recourse, okay, other than, or maybe she would have, I don't know, that's a judgment call, but that could have actually not been covered by insurance. She might have had a claim against the title company for not doing the job that they should have been doing correctly. But for the her title insurance policy, because it was discoverable, they just didn't discover it, say, they probably would not have been on the hook for that. Okay, also, when you get the actual title insurance policy, you're going to see that on the policy, it does have two names of insured. It's going to have the buyer's name or the buyer's name on it with the amount of the sale. That's the amount it's protected them for. Then it's also going to have the lender's name on there with the amount of the mortgage. Okay, they don't get insured for the whole amount. Sometimes what will happen is my client will be buying a house and I ask the insurance, the title company to, run title, get the insurance and all that. In the meantime, I'm negotiating the sales price of the house because maybe something happened during the home inspection or, there was something going on and the seller has agreed to lower the price of the house. I might forget to give that change in terms agreement to the title company, let's say, or maybe I've given it to them, but they didn't follow up and they didn't change the policy amount. So you need to go back and check the amounts of the policy And sometimes I have to send them an email just saying, you know, the insured amount is incorrect. Sales price is now X amount of dollars, please correct, and send proof of new insurance policy to me. Okay, so putting it all together, you request your title search. The abstractor will turn around and, you know, get all these liens, judgments, pull this all together. Title company then sends it for an attorney's opinion of title to the title insurance company. They will issue a certificate of title when they're happy with what they see, and then they issue the title insurance policy. And this is an example, and when I say example, it's only one page of it because they're much lengthier than this, but it's an example of what a policy is going to look like. All right, then we have, and you can read about this, it's the Uniform Commercial Code, and basically it has more to do with personal property that would be affixed to real estate. You would see this more for commercial use, not really residential use, okay? All right, so it applies to commercial law, it applies to personal property, not to real estate, and it governs documents when personal property used as security for a loan. It could be personal property that might be like some kind of a fixture. Let's say, I don't know, a fixture, they're selling these big pizza ovens or something. Personal property, but they use it as security. A financial statement has to be submitted that will give some kind of a statement of value on it, and it becomes part of real property with, you know, being mortgaged. And if it's defaulted on, the mortgage is defaulting on, it gives the lender permission to start selling off these personal items from the property. Okay, so that ends the chapter, and we're going to go through 9 really quick, hopefully, and you know, you're going to get out a little early, not that early, but let's get through this. Okay, so a document that protects against hidden risks such as forgeries and loss due to defects in the title, subject to specific exceptions, is called an abstract of title, a certificate of title, a chain of title, or a title insurance policy.
Insurance policy.
The body of law that governs topics such as security agreements, financial statements, and bulk transfers is the Parole Evidence Rule, the Uniform Commercial Code, Statute of Limitations, or American Land Title Association.
B.
The date and time a document was recorded establishes which of the following: subrogation, marketable title, chain of title, or priority of rights. Date and time documents recorded.
D. Priority of rights.
If a property has encumbrances, it cannot be sold, or it can be sold if the buyer agrees to take it subject to the encumbrances. Cannot have a deed recorded without a survey. Can be sold only if the title insurance is provided. We just talked. All right, we just talked about that. The document called title evidence includes abstract of title, title insurance, warranty deeds, or security agreements.
Title insurance.
Right. The person who prepares.
Can you hear me?
Yes.
I want to go back to number 4. If it has That the property has encumbrances. I thought it could not be sold, but it can be sold if the buyer agrees to take it? Okay.
Yeah. Well,
Okay.
keep in mind, there's different types of encumbrances too. Could be an easement, right? You know, if the buyer is okay with the encumbrances on there, then they're okay with it.
Okay.
Yeah. Okay, the person who prepares an abstract of title for a parcel of real estate, A, writes a brief history of the title after inspecting the county records for documents affecting the title. They issue a certificate of title. They inspect the property or ensures the condition of the title. Okay, so the person who prepares an abstract would be the person that is getting together all the information. So they're the abstractor, and they prepare an abstract of title for the parcel of real estate. They're hired to do that. So what are they providing?
A.
Right.
Brief history of it.
They're coming back and they're saying these are the liens, these are the judgments, you know, they're giving information, they're providing information to the title company of any encumbrances, liens, judgments, mortgages, anything that's relative to that property. A couple is frantic because they cannot find their deed and now want to sell the property. They, A, may need to file a suit to quiet title. B, do not need the original deed in order to sell if it was recorded. C, will have to buy title insurance. Or D, should execute a replacement deed to themselves.
B.
Yeah.
I'm going to tell you, with all the listing appointments that I have been on, I may have had one person, maybe two, give me their deed. Nobody ever knows what happens to their deed. They just, I don't know what they do with them, but they somehow lose track of them. And so, you know, I just think, don't worry about it because the title company is going to request it anyway. If I was to get the deed and give it to the title company is still going to request it from public records because they want to make sure that there's no fraud and that somebody hasn't gotten slick and, you know, decided to come up with their own deed. They want to see that, you know, that deed is recorded and then they're going to copy it exactly the way it was recorded. So when you go on your appointment, you know, if they say very proudly, I have the deed, you know, you can thank them for it, right? I have the deed, I made you a copy. And I would say, oh, that's wonderful, thank you. And then I'll just put it in the file and I won't even give it to the title company because I already know the title company is going to pull it. All right, when a claim is settled by a title insurance company, the company acquires all rights and claims of the insured against any other person who is responsible for the loss, and this is called subrogation. That's right. Anytime you have a lawsuit, and think about it when you're, okay, somebody hits you, but somebody hit the person in back of them first, right? My insurance company more than likely is going to go to the guy that hit me, and I get my car fixed. But the guy in back of me, right, is probably going to go and bring a claim against the person in back of him. They're going to subrogate it. Or maybe you're in a car accident and let's say your medical insurance has been paying all your bills. They want to get paid back, and if there's not enough money, they're going to subrogate a claim to somebody. All right. A title insurance policy with standard coverages generally covers all of the following except A, incompetent grantors, B, incorrect marital statements, C, rights of parties in possession, or D, forged documents.
Forged documents?
C.
Well, it's C, a title insurance policy, right, with standard coverage. We're not talking about, they're saying standard coverage. All right, to give notice of a security interest in personal property items, a lien holder must record which of the following: a security agreement, a chattel agreement, financing statement, or a quitclaim deed.
The following is intended only for mature.
Chattel agreement?
Financing statement?
Yes. Exactly. A seller delivered title to a buyer at closing.
Exactly what, if I may ask?
I'm sorry, what?
Exactly what?
The answer was 10, financing statement, and that's covered under the last section under UCC code.
Okay.
Universal Commercial Code. A seller delivered title to a buyer at closing. A title search had disclosed no serious defects, and the title did not appear to be based on doubtful question of law or fact, or to expose the buyer to possible litigation. The seller's title did not appear to present a threat to the buyer's quiet enjoyment, and the title insurance policy provided was sufficient to convince a reasonable, well-informed person that the property could be resold. The title conveyed would commonly be called an abstract of title, a certificate of title, an attorney's opinion of title, or a marketable title.
D.
It's D. Remember, there's 4 elements that make the marketable title. So with everything that we went over tonight, you're not more than likely going to remember all of this tonight. And if you don't, it's okay. Go through the PDFs. All the information that reviewed is there. And if you have any questions and you think you need more information on it, just go to the paragraph in your book and, do a quick read on it so you understand it. Okay. All right. Which of the following are traditionally covered by a standard title insurance? A, improperly delivered deeds, unrecorded rights of parties in possession, unrecorded liens not known to the policyholder, or changes in land use due to zoning ordinances.
Is it C by any chance?
It's A.
Oh.
Okay, I just want to remind everybody, make sure in chat that you just put your name and just say, present. If your name comes up, I'm looking real quick here, as Zoom user, right? I'm not going to know who Zoom user is. So when you're in the chat room, you could put your full name and then just put here so I know who Zoom user is, as an example. Or if your name comes up as something like, yes, thank you. I'm not going to mention it, but okay. Just make sure you put a chat in there so when I go through, I can pull your names off of it and mark you present.
Hi, Miss Janet. Can you hear me?
I can, Andrea.
I'm sorry. Who is William B. Peoples Jr.?
That's me.
Hi, William. You sent me a direct message rather than to everyone. I just want to make sure Miss Janet sees your name. That.
Oh, I sent it. Oh, I must have hit the wrong button.
Yeah.
All right.
I
Thank you.
I to mark you absent. Just letting you know.
Thank you, Andrea. You know
welcome.
what? You can send it to me directly so you don't send it out in mass, or if you send it out and it's in mass, it's not going to matter. I'll be able to go in and pull it up later.
No, it was like I had just put down my name and I think he clicked on my name. I don't know. And then he put his name down and he went to me instead of everyone. It was just his name. Like, I didn't want you to count him absent.
No, I know who William is.
All right.
When I'm going through, I would know that he was here. William doesn't miss.
Okay, no problem.
Okay. Which of the following is acceptable as the evidence of a marketable title? A trust deed, an affidavit, a title insurance policy, or a warranty deed?
C.
When the title insurance company settles a claim, the company acquires all rights and claims of the insured against any other person who is responsible for the loss. This is known as, and we just had this, surety bonding.
A surety bond?
No. Surety bonding, subrogation, caveat emptor, which is buyer beware, or subordination. Okay, so the insurance company is settling a claim. Now they're going to go after another party. And what is that called?
Subrogation.
Subrogation. The part of the title insurance policy that sets forth all encumbrances and defects that will not be insured against it is called a site. I know that's you, James. Okay. The part of the insurance, the title insurance policy that sets forth all the encumbrances and defects that will not be issued against is called a citation clause, a non-exclusionary clause, exclusions, or a schedule of defects.
C.
To be eligible for recording in Pennsylvania, a document must be in writing, properly executed, and the signature verified.
Acknowledged?
I'm sorry, just give me a minute here. Okay. Gonna read that again. It is D. It has to be acknowledged. So not only
Acknowledged by a notary?
yes, it not only does it have to be signed in front of a witness, but it's got to be notarized. Okay. A title search of the public records may be conducted by, all right, is it anyone?
Anyone, yes.
Anyone doesn't do that.
Right, we talked about that. Okay, so a purchaser went to the county building, the county building to check the records, which showed that the seller was the grantee in the last recorded deed, and that no mortgage was on record against the property. The purchaser may assume which of the following: that the seller did not mortgage the property, the seller has good title, no one else is occupying the property, or all taxes are paid, no judgments are outstanding.
A.
It is A. Okay, so they're going to the county building and they're checking, you know, the records. There was no mortgage that was filed, so the assumption would be that there's no mortgage on the property. Evidence of the kind of estate and all liens against a parcel of real estate can usually be proven by a foreclosure suit, a recorded deed, a court suit for specific performance, or one of the forms of proof of ownership. Okay, evidence of the kind of estate and all liens against a parcel of real estate can usually be proven by, well, all right, so you're not, it wouldn't be a foreclosure suit, so that would.
Is it B?
B.
It's D.
D.
All right, sometimes, you know, you get to these through process of elimination. All right, I mean, you know enough to know what doesn't really make sense, even if you don't know the answer. Now, you're going to do some reading, and if there's anything in here you feel that, you know, you need to review, then just go back and review it. Okay. All right, so we're almost finished. When a title insurance policy is being issued, the public records are searched, and the title company's record of title is continued to date. When the title examination is complete, the title company notifies the parties in writing of the condition of the title. The notification is called an abstract, a chain of title, a certificate of title, or a report of title or commitment for title insurance.
D.
It is D. So I'm just going to ask you a few more questions. Can anybody tell me what an abstract is?
It's a search of the liens and on the or judgments on the property.
It's a summary, right?
It's like a history.
It's what's found in the report, in the record.
Right. It's a summary report, basically. A chain of title. What is the chain of title?
That's the title search, isn't it?
Well, okay, so the chain of title would be the history of the deed.
The history of the property is like where it came from? Like who had it first, second, third, fourth?
Well, okay, so the chain of title is going to be the history of ownership. You know, the deed was passed from this person, who bought it from this person, who bought it from, it's like a whole chain and history of ownership of the deeds. Okay? Does anybody have any questions? Okay. So, at this point, you have a lot to study. I am going to work on the weekend to pull some Quizlets together for you that I hope will help you. Does anybody find them helpful?
Yeah,
Yeah, they are.
if you can remember, yeah.
Okay, so I'll keep working on them so that you have it to study. But when you have them, just keep them so that when you're doing your review for your state exam, you can go back and review them. And this way, if you've been looking at them, you know, as you go along and they come into you, maybe during your lunch hour even, or, you know, whatever, it will help to jog your memory before you're taking your state exam. Okay? If you have any questions or you feel like you're struggling or you want some additional time, let me know. And I'll put this time aside to help you. Okay?
So for next week, what's the format of the exam? Is it multiple choice?
It's going to be multiple choice. I think it's Tuesday. Let me think a minute. Tuesday, I think we're doing 12.
Yeah.
And we're going to go through that chapter. And then after we take a break, it's all going to be about reviewing for your exam. Then on Wednesday, we're going to finish reviewing one more time for the exam. And then you will be taking your exam.
Okay. Is like everything multiple choice, or would there be like parts where we have to write down like answers? Okay.
You're not writing anything down.
Okay, that's good.
Okay.
Thank you.
It's all
Janet, how are we going? I'm sorry, go ahead.
The exam is going to be.
It's all going to be multiple choice. Every single question that will be on the exam is going to be reviewed.
It's going to be from what chapters again?
Well, it's going to go from 1 through 12.
Okay.
But I'm not reviewing all of chapter 1, all of chapter 2, all of chapter 3. That's not how we're reviewing. We're only going to review for anything that is specifically related to the question that's going to be asked.
And Janet, how are we receiving the exam? Are you emailing it to us, or how are we doing it?
Nope, it's all going to be live. So,
okay, you're just going to ask the question?
Well, I don't know if I'm going to ask the question, or the last what I did was it was on Zoom and they were slides. And, you know,
Okay.
everybody has a certain amount of time, you know, to get the exam done.
So we're gonna
Dennis, or
type the answers up on Word and email it to you?
If they're, yes, if they decide
Okay.
that they're still gonna do it that way, and I'll have to check with Mark, but,
Okay.
yeah, I mean, last time I got them typed up. I got them in emails, I got them attachments, I got them as handwritten notes.
Okay.
It's going to be on Wednesday, right?
It's going to be on Wednesday, but you don't want to miss that review. And I'm going to give you an example. You know, there's going to be questions on there, and I'm not when we're doing the review, I'm not going to try to trick you or anything, just so you know.
Thank you.
All right. But I may point out something like, on the test, you may see a question that's going to be relating to what would be the best answer. And I'm going to go over it with you. Do you think you would answer it this way, or this way? And if you do, why would you answer it that way? And maybe why is this, you know, not a good answer? Even though it might be close, it might not be the best answer, right? Or I might give an example to you like, well, we haven't gotten into the math part of it yet, but, well, except for the mills. Okay, so I may ask you if a house sells for $200,000 and it's assessed at 50% and the millage rate is 5%, what would be the answer? And then we'll talk about it. But the test might say if a house sells for $100,000 and the assessed value is 25% and the millage rate is whatever, what is the correct answer? You're going to know how to do it because you already know how to do it. All you're doing is substituting your numbers, right? So if you understand it when we're going through it, you'll be fine. And if you don't understand it, then, you know, just say, I'm not sure how you got to that. Can you do it one more time, or, you know, whatever, and we'll review it again. Okay. But it's going to be a total review of the test. You know, we just want to make sure that you really understand the material, basically. Okay.
Okay.
I know everybody gets nervous with tests, and believe me, I get nervous when I take tests too. If I'm telling you, you'll be okay, you will be okay. All right, any other questions?
No.
Okay.
No.
All right.
Thank you. Have a great night.
So enjoy your evening, and I will see you back here tomorrow.
Good night.
Okay.
All right.
Good night, everyone.
Bye.
Good night. Thank you.
You're welcome. Good night.